Maybe.
My lord, with the concern of the other side, my lord, the petitioner, I am mentioning item number 3 to 12. It's a series matter, my lord. My lord, after notice, this has come for the first time. Government needs to file an affidavit, my lord. We are yet to receive an instruction. And yesterday, I have received the instruction from the government that they need further 4 weeks time to give us the terabytes comment, my lord. I have informed my senior friend
the
here, my lord.
objection is that this was a ban which was done in the name of regulation. A prohibitive ban was there. We challenged it on the ground of proportionate. They powered the Mekla Chadar in Assam. So on the first day, the interim order was refused for the time being on the ground that they will file that affidavit before 4/5 today. The fact that they have not filed, well, look, they can take time, but at least the Lordship will consider that if the next date, fixed date is given. Because I prayed that since the interim order was refused, I prayed that the matter be fixed for final, we are ready with the hearing. So since they want time, if I can propose that Lordship may fix it on the 30th.
That is item number 3. We'll let us take up the matter. We'll see what is required. If there is an interim order, we'll pass on interim order.
Interim order was rejected. That was the.
It was refused for the time.
We'll see. Let me see the order, what is passed, and then we'll take a call. Let me take up the other matters first. This is item number 3. We'll take up after 1 and 2. This is item number 3. Let me take up first item number 1 and 2.
Maybe. My lord, on medical ground, I'm making a prayer. Item 16, my lord. I'm not keeping well today. Lordship may take up on Monday or any other day.
Item
16, my lord, 1/6. Lordship has already heard this matter. My lord, I have found the division bench judgment. I'll place, my lord, before your Lordship on the next.
What is this matter about?
My lord, in fact, my lord, there was a disciplinary proceeding. By that time, my lord, it came to the logical end. My lord, he retired. So your Lordship made the query whether, my lord, a notice, my lord, is required to be issued to him, because now from the disciplinary and appeal rules, they switched over to the pension rules, my lord. And indeed, my lord, there is a division bench judgment that a show cause notice is mandatory before taking any action, my lord, under the pension rules, my lord. Because the
Under 21.
Yes, my lord. Because the notice was issued under, my lord, 1964 rules, discipline and appeal rules, my lord.
But isn't it continued on the basis of the proviso?
Yes, that I will place before your Lordship. Lordship will kindly take up on Monday, my lord. Today I'm not keeping well.
No, I also have that feeling, because there are many matters where I see that the punishment which is given or the show cause notice for which the proceedings have been initiated in view of the retirement of the person concerned, those punishments cannot be given.
Exactly. Those are not contemplated under the 1964 rules, because withholding of the entire pension is, my lord, not a punishment under the rules. It is under Rule 21 of the pension.
But if there is a misconduct,
yes,
under 21, it is only in view of 2 circumstances: whether there has been a misconduct, and the other is as regards criminal proceedings, which has also be in relation to a misconduct, which has led to the governor exercising the power under 21. Chalo. When do you want it?
My lord, any day, on Monday, your Lordship can take up.
No,
or
no,
thereafter,
not Monday.
Except 11, my lord, Lordship can take up on it. Except 11, Lordship can take up on it.
At the request of Mr. S.K. Talukder, the learned counsel appearing on behalf of the petitioner, who submits that he is not physically well, let the matter stands adjourned till 18th of May.
Lordship, may I pray for listing of an case, Lordship. This matter was last listed on 25 November 2022. And I have also picked the service, Lordship. Service has been completed.
So,
Lordship,
what is the matter about?
Suspension matter, Lordship. And suspension order was issued on 14 October 2022.
Then, till now?
Till now, Lordship, no proceeding, even no disciplinary proceeding has been
Which
initiated.
department?
Lordship, it is an mental hospital, look up to Gopinath Bordoloi, mental hospital in a Tezpur Lordship.
We'll have it on 10th of May.
Judicial Lordship, I'd like to mention for listing on Monday.
Why so?
Petitioner is not getting his pension since last August.
So there are many people. Yesterday I came across a matter where a person who was supposed to get the pension in 2012, till now the secondary education department have not forwarded the papers. Then what is the exceptional reason why I should list it and why you shouldn't go before the registry to get it listed? Think, and then again come back on Monday and again mention, will think. Give me a good reason for that. Monday, Monday you think about why the matter should be mentioned. Otherwise, take the help of the registry. Yes. Item 1.
Number 1.
Please, my lord, I am for my lord, respondent number 9, my lord, as we have been newly engaged in this case. And I have already prepared my lord, opposition opposition, my lord. Just 2 weeks time may be granted, my lord. Some modification.
Just 1 minute. Just 1 minute. There are 1 and 2 is same.
No, my lord, the respondent number 1 is the minor, my lord.
Respondent number 1 and repetition. Item number 1 and 2 is same.
No, my lord. Pension related matter, my lord. But the two different.
These are different matters. Okay. Item number 1.
My lord.
You are appearing for the respondent number 9.
9, yes, my lord. Already I have prepared my opposition, my lord.
You are the first wife, second wife. Who are you, Mr. Babuya?
No, my lord. I am the daughter, my lord. I am the daughter of the late deceased my father, my lord.
And who is respondent number 9?
Is my stepmother, my lord. Is my stepmother, my lord. Second wife of the deceased, my lord.
Second wife of the deceased.
My lord.
First wife, what happened?
Died, my lord.
Now, why are you asking for pension?
My lord, as per the compassionate family pension scheme, my lord, the dependent daughters are entitled, my lord. Now, what has happened, my lord, my stepmother has, my lord, grabbed all the benefits and the pension. Nothing has been paid to me, my lord. I am a student, and my lord, only the source is my father, my lord, while he was living. But my lord, once he died, now the whole source of my lord livelihood has been, my lord, grabbed by my stepmother, my lord. If my lord, for a moment, please to take.
But what about 2?
No, my lord, the petitioner number 1 is the minor, my lord.
Understood. What is petition number 2?
2 is representing the.
But why have you said it, made her a party?
No, my
She has
lord.
no business.
No, petitioner number 2 has no business, my lord. I have stated in paragraph 2 at page 9. Petitioner number 1 is minor, therefore she has been represented before this honorable court by the petitioner number 2, who is her elder sister.
So petition number 1 has no right. Now your claim is on the basis of 5.10.
Yes, my lord. As per the compassionate family pension scheme, my lord, 5.1.
When did the person die?
My lord, died on, my lord, 22/6/2018, my lord.
22/6/2018.
My
And when was he supposed to retire?
My lord, date of retirement, my lord, was
The date of retirement you don't know. How do you get hold of get the compassionate family pension?
my lord, I know the date, my lord.
But you don't remember. I think compassionate family pension is given only to a person who is dying in harness.
Yes, sir.
That means he has some years.
My lord, some
And
years,
that aspect having not
Yes,
been
yes.
mentioned out here
some
in your petition. How is your petition maintainable? Tell me.
Well, My lord, my lord. That is a vital information, my lord, I admit.
And more particularly,
My lord,
when his elder son, first wife's son,
my lord.
is 37 years old.
My lord, altogether, my lord, 10 legal years.
Understood.
First
Let
wife,
us see page 25.
my lord.
The husband of the petitioner, wife is 29 years old.
My lord. Roshana Begum.
That is the respondent number 9
My
as on 2018,
Yes, my lord.
which means another 5 years from down the line
I know.
would be around 34 as of now.
My lord.
Samsuddin Shahjahan,
37
the
years.
son, is
Now-
37, which
now
means he's
30
42.
42.
42 means he must have been at least born in the year 18 when the husband was there.
My lord.
Means whether he's still entitled to compassionate family
No, no,
pension?
no, no. He is not entitled.
No, not him.
The,
Whether person concerned is still entitled to.
this is pen. This is
Ah,
yes, my lord. That. No, my lord, I will, if my lord allows me, my lord, I will file an additional affidavit clarifying all these issues. my lord. Because, my lord, I also admit, my lord, if he do not left any service, my lord, after then he is not entitled, no family member. But, my lord, we are sure, my lord, that some part of his service was remained here. That's why, my lord, this order and impugn order, if my lord may be pleased to peruse, my lord, it will clarify.
where?
My lord, may be pleased to find the impugn order at page 41, my lord. Page 41 at Annex 7, my lord.
Hmm.
In pursuance of the government order number dated so and so, received from the Commissioner and Secretary Government of Assam, Pension and Public Grievances Department under the late Yusuf Ali,
And when did your husband die? That is not known.
died in
22/6/2018.
2018. My lord,
And his last basic pay was so and so.
my lord.
Now, what was his age?
That is also not clear, my lord. But, my lord, one thing is there, provided that on attaining the date of deemed superannuation, the compassionate family pension
Will stop.
Hello?
Compassionate family pension will stop.
Yes, on the, my lord, day of retirement, my lord, that
Then we will
benefit
come within the
then
ambit of the family pension.
only, yes, my lord.
Then the widow gets,
We don't get. We don't get.
unless there is some reading down of note 2,
Not
clause D.
my lord, my lord.
If it is not done,
Not done.
nothing can have, you don't get a benefit. Now, for the earlier period,
Early
your
period.
only case is go to the civil court, claim for those benefits. Why should this court pass in an order?
My lord, for that reason, my lord, I may be given some time.
Fantastic.
Ah.
Mr. A.R. Bhuiyan, the learned counsel appearing on behalf of the petitioner, seeks an adjournment to apprise this court as to what was the date of retirement
Yes, my lord.
of the husband of the petition,
No, father of the petitioner.
the father of the petition. He is granted the adjournment and further directed to file an additional affidavit in that regard. Mr. Your name?
M.H. Talukdar.
M.H. Talukdar appears on behalf of the respondent number 9 and submits that he is in the process of filing the affidavit today. Taking into account the same, let the matter be again listed on 31st of May 2023. In the meantime, the petitioner is further given the liberty to file their reply to the affidavit so filed by respondent number 9.
No, Lordship, I will file my reply after filing of the additional affidavit.
Why? You
Otherwise-
said the affidavit is
Yes,
ready?
my lord, it is almost ready, my lord. But
Mr. Talukdar,
I will have to file again, my lord.
you have to file it today. You said that.
Not today, my lord. My lord, I have to make it ready, my lord. But 2-3 days time, my lord. Petitioner, my lord, respondent number 9 would have to come, my lord.
Then why did you show that?
My lord, I have already prepared.
No, why did you show that?
My lord, I have already prepared, my lord.
Mr. Talukdar, kindly don't act smart with this. Because of the fact that I have put
my
a
humble
question to
submission,
him,
my-
does it
I
mean
have
that you are
submitted that
getting?
person.
Mr. Talukdar, these aspects, you prepare some other things. You make these type of submissions in other courts, not before this court. You are to file your affidavit. Okay, I give you time. It's going to file the affidavit by 8th of May.
Yes, sir.
File your
And number 2.
Yes.
May I please, as your lordship? My lord, the services of the petitioners, my lord, have been regularized by of an order. My lord, may be pleased to find that page 53. my lord.
Page
Page 53, my lord.
63.
53, my lord. Annex of 4.
53.
My lord.
Yes.
My lord, basing on this regularization order, my lord, what has happened? Some of the incumbents, my lord, whose name has also been regularized by this order, my lord, has approached before this honorable court.
Excess teacher.
My lord,
This is a case of this document is of excess teacher.
my lord, my lord. And accordingly, my lord, this honorable court passed an order, my lord, directing the authorities that they are entitled under the old pension scheme. My lord. And accordingly, my lord, pursuant to this honorable court's order, my lord, they are already processed and
Somebody else have got it.
yes, yes, my lord. As
Very
per
well.
my instruction, my lord. they have-
And that happened only in the case of one judgment by Justice Monojit Bhuya.
my lord,
Only one judgment.
my lord,
And that too by misleading that court that it is no, you are not there.
My
I'm not saying that.
my lord,
By misleading the court
My
that it is a case of excess teacher and an order pertaining to a drop teacher was shown.
but I am not aware about the fact.
No, you are referring to a judgment of Justice Monojit
My
Bhuya.
lord.
Kindly have a look at it.
My lord.
Where is it?
Now, my lord, the order which, my lord, we are relying, my lord, before my lordship, my lord, is at page 60, page 67, my lord.
Hmm.
Order dated 12/8/2021.
Hmm.
And my lord, as we are also similarly situated, my lord, that's why, my lord, this petition has been preferred, claiming a similar benefit and consideration of my lordship, my lord.
Hmm.
As we are similarly situated, my lord,
You kindly look into this.
my lord,
This order, where a reference is made to before Justice Medhi,
my lord.
this order
780,
is in respect to orders being passed in WPC number 3662/2009.
My lord.
This is an order passed by Justice Michael Jotan Kumar
my lord,
in respect to a drop teacher. The review petition is in respect to a drop teacher.
Right.
And that order of 3662/2009 had the genesis on the basis of the Jivan Kumar Dekkar's case,
Right.
which was followed subsequently by Justice Vaipai in the order of 12/1/2015.
my lord.
Then
My lord has remembered so vividly, my lord.
yes, I know this.
And I have gone through the my lordship's order also regarding recent judgment, my lord. So, my lord, I have not gone through the entire these judgments, my lord.
Which judgment?
3662 and 7.
Not necessary. 3662 is just following the judgment of Justice Vaipai.
My lord,
And this happened, do you know why?
my lord.
Because of the initially, when after Justice Vaipai's order was passed, then the matter was placed in order before, in a case before Justice Monojit Bhuya, wherein just mentioning that similar order, the court had passed an order without taking into account that that is an order passed in respect to a drop teacher. This is a case of an excess teacher. A drop teacher was getting some benefit on the basis of the clause 6.6 or paragraph 6.6 of the judgment of Justice Gogoi, wherein it says that for the purpose of the appointments will be prospective. However, the earlier period shall be taken into account for the purpose of pension and pensionary benefits. It is on the basis of that Justice Vaipai's order came, and thereafter 3662 also is exactly on the same line. In the review petition, what has happened, the order was said, there was a review filed by the state government stating that, look here, while passing that order, you did not consider that there is a rule 2A, which has been brought in. And as such, this needs to be reviewed. But the court say that as the order passed, or as the notification has come, on 14/7/2011. And in the meantime, the petitioners have already been given appointments. And as such, they will be entitled to. But did not take into consideration that Rule 2A, the amending rules, which is a rule which amending rules are also done under the proviso to 309.
Right.
The amending rules was brought into effect by clause 1(2) of the amending rules with effect from 1/2/2005,
Right.
for which it has become per imperium and not binding.
My lord,
In fact, yesterday I was looking into another judgment, a very recent judgment. There, what is the ratio and what is the obiter have been taken note of by the Supreme Court. How do you find out what is the ratio? It is very nicely explained. It says that you take the inversion theory. The inversion principle is you remove that thing which have been decided, take it out from the judgment, and then see as to whether the judgment makes sense. If the judgment does not make sense, then that aspect of the matter is the ratio.
very nicely explained.
Yes. And I am explaining now. Yes.
So, my lord, may I seek for an adjournment, my lord,
For what?
to satisfy my lord that whether this person is entitled to the old
No,
pension.
no, no. You satisfy the division bench after I dismiss it.
My lord, this similar person has been given, my lord,
So
from the
what?
same list, my lord, same
So what? Nothing doing. Heard Mr. A.R. Bhuiya, the
My lord.
learned counsel, appearing on behalf of
My
the
lord, at least
petitioner.
one chance may be given, my lord.
What chance? Mr. Bhuiya,
My lord,
first of all, I don't forget. Earlier, there was a matter moved as a motion by you.
yes,
On that day, you said, my lord, this judgment which is there, I have not gone through the judgment in Purnima Hall. Let me go through that.
my lord.
For which I fixed the matter after 4 weeks.
Yes, I
And
remember, my lordship is
Now that 4 weeks have gone long past. So I know you must have gone through that judgment.
my lordship judgment, my lord.
Yes. And my judgment covers this aspect. Heard Mr. A.R. Bhuiya, the learned counsel, appearing on behalf of the petitioner.
My lord,
Mr.
my lord may
R.
take up this on next week. my lord.
No, Mr. Bhuiya, kindly don't make unreasonable submissions.
My lord, the exactly similar person has been given the
So
benefit
what?
by the government by pursuit of this
So
honorable
what?
court's order, my lord.
So
No.
what? I've also passed out there that those who have been got the benefit, the state should not disturb them. That order is there.
Then, my lord, from the same class of people now, two class will be created, my lord. No, my lord, my
Mr.
lord,
No, Mr. Counsel, tell me one thing.
my lord.
When a judgment has been passed, just for example, the Supreme Court tomorrow passes a judgment and holding that this is the law, fantastic, and on the basis of which the people are getting the reliefs.
My lord.
After 2 years, the matter is referred to a larger bench,
My lord.
or the Supreme Court takes another view that look here, this aspect of the matter was not taken into consideration, and as such, the judgment is per inquiry. Once you hold, that person is not affected because for that it has already attained finality.
Yes, my lord.
But for the purpose of the other people, it is affected because there is no res judicator or a stopper in respect to those aspects of the matter. This has also been taken care of in the judgment mind. And more particularly, you may also see another judgment of the Supreme Court, that is 2006, 3 SCC page 1, the BSNL, although it's a tax matter, but then also it has been mentioned how it is to be taken into account. Anyways, enough of the day today. We finish up one matter. Mr.
My lord,
A.R. Bhuiya, the
kindly-
learned
my lord,
counsel.
may kindly-
Mr. Bhuiya,
my lord, may kindly appreciate.
no, I'm not. That is why you ask. I'm asking you to appreciate, make these, keep these submissions reserved for the division bench, because this court can't help you out, and this matter is again coming back to this court,
I know, my lord. I know, my
and
lord.
so you have no escape from the route out,
No, my lord,
and there is no change. First of all, you are referring to a judgment in respect to an excess teacher of an order which was taken by not placing the proper facts before the court. It's a very sad on the part of the council who have done this. He should have been clear to that effect that this is a matter pertaining to excess teachers. This is a matter pertaining to drop teachers. Drop teachers have a different right. The different case it is.
Lord, one thing.
And tell me another thing. Why cost should not be imposed upon you for approaching this court? Your appointment order was on 11/8/2005. You have been all along sitting out there, and it is now that you have come before this court in the year 2022.
My lord,
17 years.
my lord, before the.
You are a fence sitter?
No, no,
Isn't it the pure case of fence sitter? Yes, absolutely. What were you doing all this while? Tell me. For 17 years, what were you doing?
My lord, this regularization order of is 24 to 2005.
Absolutely.
Now, before the, my lord, date of our retirement, my lord, as the retirement date is coming, so as we are apprehending that we are not getting the pension under.
Where is the question of apprehension now? Your apprehension was very much there in that order itself. It has been mentioned that you are going to be covered by the new pension scheme.
My lord, it has not been expressed.
Absolutely, it is mentioned out there. Have a look at it.
My lord. The order of, my lord, regularization is at page 53, my lord.
Page 51. Read it. I understand and accept that the government servant pending in so and so.
My lord.
Then
Page.
what were you doing for all this while? Why cost should not be imposed now? Tell me. Enough. I'm going to dismiss now. Why cost should not be imposed for abusing the process of the court? Why have you approached this court after 17 years? Tell me.
Lord, this.
The cost should be imposed upon the petitioner or the council. You must have you given any idea to the petitioners concerned that look here? You have also not paid the court fee also. I dismiss it, also give you a direction to pay the court fee also. How many petitioners are there?
35.
35 into 50. I heard Mr. A.R. Bhuiya, the learned counsel, appearing on behalf of petitioners. Mr. P.N. Sharma appears on behalf of
1, 3, 4, and 5.
respondent number 1, 3,
4, and 5.
4, and 5. Mr. R. Borpuzari appears on behalf of the finance department.
Respondent 2, my lord.
The case of the petitioner hearing, the case of the petitioner's hearing is that the petitioner, having been appointed the petitioners are entitled to the old pension scheme in terms with the Assam Service Pension Rules 1969, for short, the rules of 1969, and not the new defined contributory pension scheme 2009, which was brought into effect by the of notification dated 6/10/2009. It appears from a perusal of the petitioner that and more particularly to the order of appointment, the order of regularization of the petitioners dated 24/2/2005, dated 17/8/2005. that the petitioners herein were initially appointed in excess of the post during the period from 1/3/1991 to 30/11/1996. And upon being inquired into by the one-man committee headed by Sri S. Monoharan IAS, and subsequently by the task force of the district level screening committee, the services of the petitioners, along with the others, were regularized with effect from their joining against the vacant post. In fact, the issue involved herein has already been dealt with by this court by a detailed judgment in the case of Purnima Hor versus State of Assam, reported in 2022-23 SCC online GAU 13-0.
The judgment dated is, my lord, 31/3/2023.
No, it is not that.
Yes. Sorry.
2023 SCC online GAU 1165. Paragraph 105 to paragraph 111 of the said judgment categorically deals with the case of excess teachers and their entitlement to entitlement only to the new defined contributory pension scheme 2009 and not to the old pension scheme in terms with the rules of 1969. It was categorically held by this court that the petitioners who were appointed, petitioners therein who were appointed as excess teachers in the category of excess teachers, excess teacher. well, would not be entitled to the old pension scheme, in as much as their period of service rendered earlier prior to being regularized for the purpose of pension was totally misconceived. At this stage, this court also finds it relevant to take note of the submission of Mr. S. A. R. Bhuiyan, the learned counsel appearing on behalf of the petitioner, that the coordinate bench of this court in WPC number 8694/2018 and other writ petitions by the order dated 12/8/2021 had held that the petitioners therein would be entitled to, would be governed by the Assam Service Pension Rules 1969 and not by the NPS. A deeper analysis of the order dated 12/8/2021 would reveal that the coordinate bench of this court was misled by to applying the law, applying the order passed in WPC number 3662/2009, as well as also the order passed in review petition number 16/2019, which were matters pertaining to drop teachers. It is relevant herein to take note of that in a similar circumstances, the coordinate bench of this court was also misled to pass an order dated 4/8/2015 passed in WPC number 5705/2011. Again, on the basis of the order passed on 12/5/2015 in WPC number 4169/2009. This court, in its judgment dated 31/3/2023 in Purnima Hor Supra, had also dealt with the said issue in paragraph number 110. Paragraph 109, paragraph 105 to 110, 111, paragraph 106 to 111 of the judgment in Purnima Hor Supra being relevant is quoted herein under. Next. Taking into account the above law laid down, this court therefore is the opinion that the petitioner is not entitled to, petitioners are not entitled to the benefit of, are not entitled to the pension in terms with the rules of 1969 as well as also shall not be entitled to subscribe to the fund in terms with the General Provident Fund, bracket Assam Service Rules 1937. The petitioners herein shall be governed by the new pension scheme applicable to the state government employees of corresponding rank. This goes further, taking into account the judgment in the case of Purnima Hor, Supra, as well as the office memorandum dated 1/2/2021, further declares that the petitioners herein shall be eligible for the benefit of retirement gratuity and death gratuity on the same terms and conditions as are applicable to employees covered by the rules of 1969 in view of the office memorandum dated 1/2/2021. With the above, the petition stands disposed.
Right.
Deeply obliged.
Item number 3 to 12.
My lord, 3 to 12, basically we have challenged, basically a prohibition order passed by the Assam government of power loom products under a reservation act known as the Handloom Reservation of Articles Act, oblivious of the fact that we have never violated the exemption because Mekhla, Chadar and all were exempted from the operation of, so that the handloom products can be further, can grow. What we did, Lordship, our entire case hinges on the fact that we mix, Lordship, I'll take your Lordship to the act, the exemption clause at page 53. The act talks, it's a central act known as the Handloom Reservation of Articles for Production Act to protect the handloom industry. Lordship will come to page 53, table 11. Can I read?
Yes.
Chadar, Mekhla, Phanek.
Lordship, my senior is on legs in court one. Kindly pass over the matter for time being.
Fantastic. Don't worry. Let me hear it. Then if I pass an order, then your senior can very well go to court number 1 and appear.
Chadar, Mekhla or Phanek?
Page 54.
Yes, Lordship. Page 53.
What is this? In exercise of the powers conferred on the section 3 of the Handloom Reservation of so-and-so and in possession of the order of the government, we have been satisfied after considering the recommendation made to be. Okay, now you come under Mekhla.
Our case was that the specification which was there in the act, we never violated because all products are done through product codes is there.
Who are you?
I'm one of the person who deal in textile.
Where? Outside.
No, here in Guwahati.
Now, what is the problem out here?
The
Means
problem is that we
what
have
they have
been
done?
diversifying a product. The Assam government just before Bihu came up with a notice from the Handloom Directorate, backed up by the Deputy Commissioner, stating that from now onwards, the diversified products which we could make, you cannot make any product.
Really?
Because it falls within the definition of Chadar Mekhla under the Act. And
Where is the
yes,
communication?
very funny. Well, virtually in the norm of regulation, they prohibited us. That's our case. Lordship will come to the impugn order at page 54.
Page 50?
54, Annexure E.
54. Yes.
This is from the Department of Handloom. This is to inform you that the vendors of all textile establishment and commodities in Kamrup district, that according to the Handloom Reservation of Article of Production Act, the state of sale of gamucha, mekhela, chadar, dakhnas which are produced in power looms of other states is strictly prohibited with immediate effect.
You don't come within that.
No.
Okay. Then
Therefore, you are requested not to sell such textile within the territory of Assam. Otherwise, appropriate action will be taken. In addition, I would like to inform you, you requested to encourage indigenous weavers and benefit from them financially by arranging the
so
sales.
page 54 is the impugn order.
Yes, and there the deputy commissioner.
Then how are you affected?
My lord, what has happened just before Bihu, when we were about to sell products, and we are code, there is a product code which says, the act says that cotton, there is a specification. You mix cotton with silk for the mekhla chadar, which is exempted. We don't touch that. We know our limitation. We do it with cotton and polyester, which is an amalgamation, different product, and we have a different product. We get it from the power looms from Gujarat and all, and we sell it. All along we have been doing it. This time they put
So you get it from the power looms outside.
outside.
So this is a ban is only in respect of power looms of other states.
Yes, and what they do,
So you import it from outside.
yes, and then
That
as
is what I was asking
Yes,
you.
yes.
So you are you
we
sell it out here
outside it out
after importing it from
from
outside.
outside, and we make diversified products which don't come within the ban. So that was our case. In fact, your lordship will come. We have specified it.
So
as to-
here your case is that there cannot be a ban
Yes,
on
total ban.
bringing outside things.
Products which are diversified products, not coming within the purview of the handloom, because we want the handloom industry to grow. We know our limitation, because the handloom industry table 11 specifies that mekhla chadar and other local products from Mizoram, Nagaland, and
Is used for covering lower and
Yes.
upper part and is
covering
manufactured
lower and
from
upper part of
cotton
the body,
or
and it is
silk yarn
manufactured
or
from
art
cotton
silk
yarn,
or in any combination thereof.
woven in plain or twill, weave with check or stripe, design irrespective of the count and dimensions, and it's characterized by border or cross border with extra wrap or extra weft design, and includes Kon of Mizoram, Dhara of Meghalaya, skirts of Arunachal Pradesh, Riha of.
So you say
Yes.
what you are importing is
Yes.
not a mekhla chador
No,
because it does not have
the
silk,
it doesn't have silk and
but
cotton,
as there is a combination of
No.
cotton with polyester
polyester and viscose.
or viscose, therefore it does not come within the ambit of cotton yarn or silk yarn or
Yes.
art silk yarn
Yes.
or any combination thereof.
Yes.
So the combination thereof has to be with art and with cotton and silk.
That is good. In fact,
So your
I
case
get
is
a
the case
support,
of polyester.
and I get a support from a judgment, not only of today, of course, because I thought time would be taken. There's a Supreme Court judgment of 2010 which says you can diversify. I fall within that.
2010
2000, if I'm
or this 1993. Parvez Akhtar.
yes, 2010 5 SCC 349.
2010, you have not given that. No? Here, I have two judgments out here. One is by Justice Krishna Murari and Ravindra Bhatt
That
on
is-
20th of
yes,
February.
That is the proportionality doctrine I brought in. Because the
Okay.
least restrictive choice was not done, you put a total put a ban. And in fact, what has happened, we lost it during the Bihu. We could not get an interim because we wanted that at least the.
So you want now to do it at Katibihu?
Well, that is always open.
Okay.
And what has happened, the deputy commissioner has now brought in the penal clause and now seizing things. In fact, we have brought in 10 has come, 5 more persons have filed yesterday. They're seizing the materials, and so that part I wanted an injunction pending the final decide.
Understood, but what is the power exercised for
Let's-
seizing?
Well, that we don't know. That was the instruction we got from our clients. In fact, if I may read the DC's order, Your Lordship.
Because page 54 says
Yes,
you can't import.
yes. My lord, what has happened? This is the order passed.
Page 54 says strictly, which are produced in power looms of other states is strictly prohibited with immediate effect.
Yes, my lord.
Now, if it is prohibited,
Yeah.
what power the DC is exercising?
My lord, there are, in fact, under the that act, what you call the Handloom Act, there are some penal provisions. Because in fact, in one of the orders, they say that if not, yes, this is the order. They said you will be put behind bars and all the penalty.
Where?
So that's causing a fear amongst the traders. Page 59. This is by the Secretary of Finance and Handloom and Textile. As you are aware, can I read? That under the Handloom Reservation Act 85, there are 11 numbers of articles with certain technical specification, including Assamese, Gamucha, Mekla Chadar are reserved for exclusive production by Handloom. In this connection, please refer to the office letter dated, communicated to you from the Director Handloom and Textile. If the items are produced otherwise, then the violation would be punishable as per 10A of the Act, which will be with the imprisonment for a term which may extend to 6 months or with fine or extend to 5,000 per loom, by which these articles or class of articles produced or with both. You are aware, you may also aware that the Director of Handlooms have also buying 31 numbers of traditional handloom item through Swarnavir Nari portal in different procurement center in the district subdivision, where 5 lakh of traditional weavers have registered under the portal and sell their products as per the specification given by the department. It's a matter of concern that some unscrupulous traders are importing cheap powerloom made of Gamucha chadar to the state and are selling the same at much lower price. This has adversely affected the handloom industry and the poor weavers in particular, which has been deprived. In this connection, the state has launched an intensive drive against powerloom products, especially Gamucha product, Mekhela chadar, with effect from 1st March onwards. The district magistrate may urge the textile merchants to stop importing machines from Gamucha, made Gamucha chadar, so that they don't suffer any loss. In view, I request to go kindly your good office to intervene to stop the power loom made Gamuchas in this.
And what is this order passed by Justice Surana?
Yes, Malad, here what has happened, NITs were called and this issue was also taken up, and the learned single judge says Lordship will come to page 25. This argument was rejected, saying that you can diversify. If I may read paragraph 25, page 74.
Oh, this matter. I remember it came up once before me.
Oh.
This is pertaining to tailor-made condition.
Yes.
This is what has been mentioned. Huh? It is tailor-made so that it benefits some people,
Yes.
and as such, it challenged the tender condition.
Yes. So paragraph 25 says that, if I may read, Lordship, very
Yeah.
short. No documents has been brought on record by the petitioner to show that a particular item peacock which has to be procured through the impugned NIT as same as Fun Act, which is covered by entry 11, same entry, wherein board refer table B, that it as in the range as provided in the table appended to the order bearing 39/2008 does not include the specified variety of chadar, mekla, dokna, peacock, which are sought to be procured through NIT dated such, corrigendum dated such, herein referred above. In this regard, it is reiterated at the cost of repetition that as per the said to impugn NITs and corrigendum, the fabric prescribed for chadar for Anganwadi workers, chadar for Anganwadi helpers, mekla for Anganwadi workers, and mekla for Anganwadi workers were blend of cotton 70 and polyester 30, which is our case. Thus, as polyester is not included in the range mentioned in the table referred, the goods chadar, mekla, dokna, peacock, for which the impugned tenders were called, cannot be held to be reserved for exclusive production by the handloom sector. The second point is answered. So that's our case, simple that you have basically prohibited in the garb of protecting, you have
So
prohibited.
your thing is that whatever you are bringing
Yes.
does not fall
Fall
within
within the
the
purview.
ambit of entry 11.
Yes, and there is no legal exemption. We fully comply. We want the handloom industry to develop. We know our limitations.
But how is he going to develop if you are bringing cheaper ones?
That, of course, is for the public to decide what to get.
No,
because
obviously, how
Yes,
can
that is right.
once you bring a cotton, a cotton would be different. The price of cotton and
But-
price of polyester would be different.
But diversified product is can be done in terms of the Supreme Court judgment that you can do diversified. We are doing
But
diversified.
if you are making the same, you can't make head or tail difference between them. Except a person with a acute taste of cotton and silk, he may do so. Otherwise, you
But-
can't make a
But the
difference.
table specifies that there is no bar for the if we can do with other products. Because the product code, in fact, I've specified, if Lordship will come to a particular paragraph, where I have specified that the year, Lordship, page 14, paragraph 9. There I specify my case further. Page 14, para 9. Para 9. That the
Let the
petitioner says that the
which
product which they are purchasing made and
and
manufactured by
product
Palooms or
that
selling under
Palooms
them
are
to their
selling
vendors are of
under
different
them.
composition not within the ambit of range or articles whose specification has been mentioned in any range of product which are specified in the Handloom Reservation of Article for Production Act. The said fact is also fortified by the petitioner as the product code under which the goods are being produced and sold is under HSN code 5407-52110, which makes the product distinct and different.
No, I've got your point, Mr. Das. Only thing is, if you are going to bring those, what will happen to the handloom industry? Technically, you have a case. Very well. Technically, absolutely. You have. But the intention behind the prohibition, I am not in regards the seizing and all. How is it done? I think we need to look into it. Yes, madam, where is your person concerned? Under what provision are you seizing?
Lordship, as per the government notification, so we have some, in this regard, the government published one notification, Lordship, and accordingly, Lordship, that was.
Where is the government notification?
Lordship, it will provide by the handloom department, Lordship. The department council will.
This matter was listed before Bihu.
Lordship, but
And till today, nothing. Because what is happening? Otherwise, I'm not concerned. But the question is, you can harass them. Yes, you can stop the prohibition. You can stop the on the basis of that order, that notification order at page 54. You can stop an import. But what is your power? A power cannot be gathered from Annexure H. A power has to do something, has to be on the basis of an act, rules, or law.
Lordship,
Where is the law for that?
on that regard, Lordship,
You don't know the law.
The deputy commissioner follow up the instruction of the government, Lordship, and the government council.
The government may say tomorrow that bring everything which is there, these all these things, but what is your power? You have to show that there has to be a source of power to do something. Now you see, this 3/2/2023 is issued by the Superintendent, Department of Handicrafts and Textile, Biswanath Sir. No, he referred to page 54. Notice. Notice is to all vendors not to do it. Now, if you are issuing a notice, you have to have the power to do so.
Lordship,
Where is your power to do so? To prohibit.
Lordship,
There has to be some order of prohibition.
some appraisal is necessary on this.
No. Appraisal is a notice. But where is your power that you can stop those things which wouldn't come within the ambit of 11? Unless you amend 11.
Right.
Very well. If you amend 11, you can very well do so.
So far, Lordship, so far the petitioner concerned, Lordship.
We don't require an
not,
affidavit.
I-
This is a
Lordship,
pure
Lordship.
question of law.
Lordship.
Isn't it, Mr. Sir?
But so far, in the event, in the eve of
First, you have to
Lordship,
show me the power under what you have issued this notice.
Lordship,
You have a power to prohibit, but where?
Lordship,
Then, what time?
Lordship, 2 weeks time.
What? 2 weeks time? No. Then you give an undertaking
Yeah.
that you are not going to harass them.
They are harassing.
They won't sell, but you don't harass them with their product. Don't put them to arrest.
Yes.
Then Lordship, we'll appraise this matter
When?
next week, Lordship.
No. Give something so that they are not harassed. Don't harass them till the next day. I'm not saying that they should not sell it. Mr. Das will give an undertaking that they would not sell.
Yes.
But you have to also not to do it, because on one hand you have not filed your affidavit.
Yes. That's it.
Yes, Mr. Dhar. What is your power to issue this notice at page 54?
My lord, actually, this matter, Advocate General is appearing. If I need to argue, my lord, I have to call him.
Call him.
My lord, today was fixed for my lord. This only on the last occasion, notice was issued.
No, no. First of all, you can't threaten to arrest them unless you show me the power. How are you arresting them?
Whom we have arrested, my lord? We haven't arrested anybody.
You are seizing their goods. What is your power to do that? Don't take coercive action. They won't sell till the next day. Then what is your problem? They are not going to sell it. Your only problem is once they import, they are going to sell it, and thereby it will affect the local market. They won't sell it. They give an undertaking.
My lord will take up the matter after some time, my lord. I will just
Okay.
inform the advocate.
Two.
After some time, I will just, he's in court number 1, I will bring him. I will bring him.
We'll take it up at 2. It can't be at his exigencies out there that whenever he comes, I should take it up. I'll take it up at 2. Ask him to be there. Get your instructions by then.
In fact, Lordship, during this.
Only thing, you do wonder, they won't sell. They will give an undertaking that they would not sell anything. But don't take coercive measures for the purpose of arrest or what you call seizing till you file your affidavit. You have to do something to that effect. What is your intent there?
Well, that's well, not to take any coercive. We wanted
Not coercive.
coercive action.
Restrain from giving
Because the
effect to
mayor
the.
is
No, no,
right.
these I'm not saying it.
Yes.
I'm only saying
Well,
that.
this coercive part was urged by me on the
No,
last.
you are not going to carry out any business in respect to what you import from the parliament. No, you are not going to carry out any business. But
Coercive action.
till the filing of the affidavit or the next date, you should not. They should not also take coercive measures for seizing or arresting or harassing. 2.
I'm coming.
2. Mr. Das, I'll take your matter too.
We have the partner.
Oh, that matter.
Item number 13 to 15 for hearing, part heard.
That is that matter.
Yes, well, that OBC.
30 to 50.
No,
Oh, so those 3 matters.
well, the only question was whether the mandamus could be issued in view of the Indra Swani's case. That was the point, and the respondents were directed to take instruction.
An executive order made under transfer is enforceable the moment it is made an issue. Therefore, submit that in terms with the state order dated demand, the office memorandum dated issued by the AI is in exercise of an as such the office memorandum becomes enforceable. Yes.
My lord, in this case, my lord, so petitioner, my lord, apparently, my lord, this notification that has been there claiming their age election, my lord, 2018, after last date of the advertisement, they have applied it as pursuant to advertisement. At that moment, my lord, age was so and so, 43 or something. And subsequent the notification that has been issued by the government for MOBC, OBC candidate, that is prospectively effective, not retrospectively. Because we have so many cases here. Our court and Supreme Court also my lord, says, no, Supreme Court says when the last date is given in the advertisement, that is on that day, the qualification age is to be counted, not beyond that. It is simple thing, my lord. So I have seen here, we have filed affidavit also, my lord. We have so many cases, and my lord, he says one case, my lord, 92 Indus Swahani case.
Mm.
In this one case, page 766 says, my lord, what says, my lord? The executive order making provision under Article 16(4) is enforceable at the moment. It is at the moment it is with a suit. And paragraph 37, 38. Once we hold that provision under Article 16(4) can be made by the executive, it must necessarily follow that such provision is effective moment it is made. So, how it is applicable? Applicable in favor of us all, because 18 notification will be effective the moment it is made. It is cannot be retrospectively given effect to favor their to relaxation of age. There cannot be. That is the case. So our High Court,
And what will happen if this benefit is given to them?
Yes.
Then there will be many other people who will be
definitely
affected,
it will violate sir, Article 14 and 16 also, my lord.
and
Other people
thereby
will come.
your entire selection will be done.
Yes, and there will be chaos, my lord. It cannot be very smoothly. They cannot select it. APSC. So it is, my lord. It will be bad in, my lord, in future also. So our High Court also, my lord,
What have you done to the representation they have submitted?
regarding depression, my lord, represented by her by the standing counsel, and my husband, but she says, but there is they could not, my lord, test out it. Yes, what they represent, meaning that they have not received, I think, my lord,
Who?
representation, the department. The department over telephone informed the standing counsel, Mr. MS Kotoki, that they Phil, no, you tell.
They are not able to trace the applications, my lord, representation.
Well, it is received.
And
One of the annexures I have made, they have received it. They have given the date and they have put up for endorsement. What more is required? Well, the annexure A12 is the receipt we took.
812.
Yeah, A12 of our additional affidavit which we filed.
810, 812. Additional affidavit. Yes. 812. To the Commissioner, Animal Husbandry,
Yes, Lord.
so and so. Where is the receipt?
Page 9. Right.
So and so, Malaka DS Srimati Mosumi Senior Assistant put up to demand of demand. Who has received this?
But if 5919 it is given 5419 it is given. Because in our petition we say that we received it, we get it receipt. All 7 give their representative.
Mr. Das, this 16.4
Yes, sir.
is a provision which enables the government to take steps in terms with for the benefit under 16.
For reservation of the
For recruitment and
enabling
promotion.
provisions.
Our case is recruitment.
Whatever maybe, they can do so. So it is within the hands of the executive to take steps in terms of 16.
Yes.
Now, if that is so, can this go direct the state under 16.4
Yes.
to exercise the power?
Yes, because this has been dealt with by the learned Honorable Justice Chalameshwar in a case from the Supreme Court, where this case arose. This was regarding whether promotional benefits in the bank has to be given to the reserve, because the High Court says that it's an enabling provision. If it is not enabled, no mandamus can be issued. Supreme Court rejected in para 24 and said that once they have enabled it, it's an enforceable right and they can claim it. Mandamus can be issued. Paragraph 24 is very specific. In fact, this is one of the judgments I took in the Bhagwan Partner's case also.
We make it clear that there is no dispute of the constitutional research under 15 and 16. So far as this
If I may,
now what do you say this? Para 24
yes,
in
Lordship.
between.
Because I had built up a
In,
case.
in the opinion of the state,
Yes.
kindly see this, insofar as making of provisions for reservation in matters of promotion to any class or classes of post is concerned, such a provision can be made in favor of SC and ST category employees if in the opinion of the state they are not adequately represented
Yes.
in services under the state. Thus, no doubt, power lies with the state to make a provision. But at the same time, the court cannot issue any mandamus to the state to necessarily make such a provision.
Yes.
It is for the state to act in a given situation and to take such an affirmative action, of course, whenever there exists such a provision for
Yes.
reservation in matters of recruitment or promotion, it would bestow an enforceable right in favor of the person belonging to SC/ST, and on the failure on the part of the authority to reserve the post
While making
selection, the beneficiary of these provisions can approach the court to get their rights enforced. What is highlighted is the existence of provisions for reservation in the matter of selection or promotion, as the case may be, is the sine qua non for seeking mandamus, as it is only when such a provision is made by the state a right shall accrue in favor of one. This goes against you.
So the reservation of post only, that has been done by the government already.
No, you see, when the power to reserve or give certain benefit is being given, and in exercise under 16.4, that is absolutely, yes, after doing so, if there is some any illegality or any transgression and thereby affecting the rights of the beneficiaries, obviously this court would have the power of judicial review. But prior to that, would this court would it have the power to do that?
It would have the power for the simple reason that
Means or in other words, this court has to say that the state, while exercising the power under 16.4, should have done so retrospectively from this, not to this. But does the court have the power to do that?
The
decide that?
advertisement specifically says that the OBC reservation is there. The fact that OGB reservation is there, the 16.4 regarding selection, recruitment is already, it has enabled. The fact that the central government's notification, my lord, what has happened in areas where there is a vacuum in the state takes resort to the central OM, which has happened in Assam in the post-based reservation, which in the Pator's case was discussed. There the central OM also talks about post-based reservation in terms of Sabarwal. So here the central government's 3 years was already there, and your lordship will find that in each orders of 16 and 18, they talk about existing provisions given to the SC, ST and the other categories. Other category always means OBC. And
no, other category means other people, a person who is a war veteran. This is what he has produced on the last occasion, isn't it, Mr.
Yes. To that point, Lordship was not satisfied.
And
only one point is to be clear, that is this regarding notification.
And
Relaxation
in
of
fact,
age.
your
My lord,
lordship,
as soon as the advertisement is my lord, made, it is started the selection process. And the last date is given to apply. On the last date, whatever the education qualification and also my lord, age is required, that has to be fulfilled by the candidate, not beyond that. There is no power of the High Court, my lord, to say only 16 posts has been only reservation of posts. That is also if the government think that this person belongs to so and so community is not educated representative. my lord.
Mr. Das,
Yes.
recently I came across one judgment.
Yes.
State of Uttarakhand versus Rachna Hills. This is recently being given by Justice Narasimha, I think on 27th of April. You see, the concept in Rangaya was changed in Rajkumar. But that was in a case of a promotion.
Yeah.
But this aspect was brought in to a direct recruit selection. Meaning thereby, that at the time when the advertisement was issued, there was a particular regulation. Selection was almost complete. It only required an approval. Now, once this approval was sent to the state, the state came up that look here, we now have a different form of a selection in view of our amended regulation, and accordingly returned the file to hold a fresh selection. So these people challenged it and said that you see, entire process was over. Selection, it was only a formality of an approval. So the single judge out there directed that you give the approval, and it will be regulated as per the old rules. Rangaya.
Yeah.
Then the matter came up that after that it was specifically held out there, but then also the government said that no, we are going to follow the new amended rule. Then the matter was again challenged. Then a contempt proceedings was drawn and all these things. And at last, the government said that, okay, we are doing it. And there was a direction to the government to do it as per the old rules. Matter went to an appeal. Thereafter, the matter went to the Supreme Court. The Supreme Court categorically held, thereby importing the principle of Rajkumar, and say they will be now regulated by the new amended rules. After the selection proceedings have gone ahead, was initially a selection proceeding. Now, can you bring this out here?
in fact, when we approached this court, the court granted us stay, and we were allowed to sit, subject to. Definitely, well, at this point can be because our rights.
Because the
vested
problem,
rights-
there is a big problem for this court to pass a direction, because this will change the entire complexion.
Yeah, but another, on the last occasion, if I remember, on the first day when I argued about 7 months back, I had two limb of arguments. The second limb, Lordship had said that that was quite an encouraging limb. The limb was that since it is a constitutional provision regarding OBC reservation, because concession, exemptions, these are also falls within the definition of reservation, because it's a mode of achieving equality. So a purposive interpretation is given that there is a gap of 50 days. So I say that there cannot be a vacuum when you are, because that vacuum, if it is done, which the government has done it, bringing a very doctrinaire approach, the court's purposive interpretation will help in, and that as if the 16 OM is the continuation, and this gap of 55 days by which they are debarring us from getting the benefit may be interpreted as a part of the purposive interpretation to give effect to a reservation policy for affecting the socially and educational backward community. In fact, that in my additional, the problem is happened because this was dealt with another set of lawyers. When I came in, I developed it and I filed 2 additional affidavits to bring home those points. Those were never brought in the original petition. So this point, Lordship, on the last occasion, I remember Lordship says
Understood,
that
but then also,
this
would
is
it-
an issue.
no, if this court is going to say that,
Yes.
wouldn't this court also be saying or reading down to the fact that these 50 days be considered?
No, but what has happened now, the intervening time, if Lordship knows that the selection happened and by on merit, we file RT and we got it that on merit.
Yes,
of,
six,
three got it.
three have got it in a
and
redacted.
on merit we get it. When we go and merit, we go as a member of the unreserved. We don't go by RT Sabarwal, clear case. And that's the case which is troubling Assam in my case, reservation case. So, in fact, that part also, because ultimately the court has that enforceable right comes from that part. Lordship is not precluded from, because anyway, assuming whatever order is passed, will, even if it is challenged, but the fact that these three people, these are all unemployed people, they have lost their job, they overage and all. So if at all, at least the representation part, because of the representation which is pending, let them pass it. Let them disclose the results and if because anyway, one thing we know of the three we got, and we got it because we were allowed by this High Court to sit in the examination. That can be done, Lordship. That's it's after all the Court of
Understood, but the High Court allowed you to sit in the examination. Would it get you an enforceable right?
No.
That would not give you a right, but I think
But in the meantime, the situation has changed that suppose the three persons who have got selected, at least the satisfaction that we.
hey, Kali, মই যে আপোনাক WhatsApp কৰিছিলোঁ, সেই judgment-টো ওলাই দিয়ক. Give him a call.
In fact, the government never came up for vacating of that. If they were so strict that this case there's no leniency, they could have gone and appeal or vacated the order.
No, government is not bothered. Government thinks that they will, it is their responsibility of the petitioners.
Yes, in
if they
fact-
want a job, they will come in.
Yes,
Why
my
should
lord, in
we
fact,
bother?
in 1996,
Isn't it, Mrs.?
Yes, Malab, because in the advertisement, they have stipulated the qualification, age, each and everything. And beyond that, they cannot claim. Beyond that, they claim. If that their claim is admitted by Lordship is passed out, there are other people who will come. They will say, we could have applied. Then it is deprived of them, my lord. So legally not. In the Malad Supreme Court, I get enough reason. I provided Lordship
surmises and
three
conjectures,
cases, my lord.
other people. My lord, these sort of arguments, I fail to understand that if an order is passed by this court, my lord, we have to state certain facts. The counsel for the government, without imputing motives, always make a submission, no order should be passed because it will open up a Pandora's box. So that doesn't mean that if a right is violated, the Lordship has a power of judicial review. It's an equitable.
No, that obviously.
always
No,
these
opening up
arguments
a
made.
Pandora's box
Well,
is
this is
another
an
aspect,
argument.
which tells
This is different thing.
for that the state government is going, they're responsible.
Yes.
That is not that
But
if there is a
this sort of
continued
arguments
violation,
are
I'm
always
not on
made
that.
in this court, I find, from the other side,
No,
state side.
that cannot be the
That
reason
cannot be a
behind.
legal.
No. What I'm saying is, I think what Mr. T.C. Sutia is also saying is that if we change this aspect and say that the person concerned will be getting the benefit, then there are many people who would have otherwise participated.
Exactly.
What will happen? Their rights under 14 and 16,
No,
the
that-
entire selection will go.
I fully appreciate this part, but at the same time, at this stage, the exigencies of the situation, on the facts of the case, Lordship, can I not pray that at least the results be declared? That will be sufficient. Because the fact that they gave a.
If I remember correctly, Mr. T.J. Mohanta's submission is,
Yes, that
I can't resolve the results unless and until he has the age. That is the problem which they are saying.
no, it is their problem because when I give my RTI, they is sub judice will comply with the court's order. So
But thereafter, we don't see Mr. Mohanta. Where is he?
yes. In fact, on the last occasion, he only said that representation can be, if he comes,
No, representation, that has been, my lord, mentioned by our standing council. That was not traceable, my lord, whether their result is not known. Hey, border it, my lord, we have forgotten the representation, my lord. But whether they have, my lord, crossed the bar or not, age bar or not, it is, my lord, admitted fact they have overaged. So overaged person can be allowed, my lord. We have got the Supreme Court judgment, my lord. I am placing 3 judges, my lord.
Now I can water down my submission to that only, representing nothing more. Because I definitely appreciate your lordship. That will be setting up on the facts also. It will be difficult for lordship. So at least only that I can praise a court of equity, nothing more.
These 3 judges, my lord, Chandana Deka, Ashur Kolita and Mukherjee. And that is Mukherjee, my lord, K. Mukherjee. Yes, K. Mukherjee Supreme Court, versus State of Andhra Pradesh. Says, my lord, all these things are in favor of me, not against the petitioner, my
No,
lord.
I think K. Manjushri went to the full bench, no?
Oh, yes.
5
She meant
judges.
Yes, yes, sir.
No, K. Manjushri has gone to
Manjushri.
5 judges. That
Yes,
is,
3
they
judges.
mention, no, this is a 3 judges. But this is, I think, being referred to a larger bench.
On what?
Because in paragraph number 29, if I remember correctly, yeah, this is a particular paragraph here. Yeah, yes. We hereby so and so amend without applying the amend. The merit list will have to be prepared in the regard by adding the marks so and so thereafter amend. Which paragraph you are referring
Lordship
to?
Palace, the
They
paragraph.
are in fact this
Yes, 10
K.
paragraph.
Manjushri
Paragraph
refers out there and quotes a paragraph of another judge.
Paragraph 10, my lord.
Paragraph 10.
Yes, 9 and 10, my lord. State petition this case. Yes. And 10, my lord. The appeal is by the K. Mojusi, whose name was found in the first list. She contended that the minimum marks for interview not having been prescribed either under the rules or by the resolution dated 30th November 2004 by the Administrative Committee. The action of the full court alerting the norms of selection by introducing minimum marks of interview, alert completion of the selection process would amount to change of rules of the game. That is, my lord, the appointment of judge, district judges. The full court says marks was imposed after the interview was started and completed. So it is not allowed.
No, understood, but there is K. Manjushri holds at a particular paragraph after taking into account certain judgment. Once an additional quality of yeah, paragraph 28. I still remember. And so this court observed that the rules of the game, meaning thereby that the criteria for selection cannot be altered by the authorities concerned in the middle or after the process of selection has commenced.
Yeah.
This is what you are emphasizing on. Because it would be arbitrary to do so.
Exactly.
But does it say? Have a look at this judgment. Can we import this principle? Because here what has happened, Rangaya was held to be in Rajkumar, it has been held that no, this is no longer a good law. But the concept of Rangaya, which was promotion, has also been brought in and the selection process has already started. And now they are saying that we are going to go as per the new amended rules.
Yes.
Now, taking away the basic right.
If a particular age relaxation has come in, wouldn't that benefit be given then? Because Mr. Das, this court normally don't pass an order for consideration. Because merely passing an order for consideration without saying your entitlement.
Yes, yes. That gives a leeway to the government.
No, the government would is not bothered.
Yes.
So
in fact,
my basic idea out here is, if I ask them to consider, there has to be based on a legitimate expectation of the state.
Yes,
of the person.
In fact, that was the reason why your lordship said that the second part theme of my argument, that the purposive part, because this is a writ court, equitable court, and in reservation matters, the court have always taken the purposive interpretation, not that doctrinaire approach. That's the point. In fact, the Supreme Court in 1996, Chandramani's cases use a usually Supreme Court doesn't use sharp words for the government. They say that government machinery basically is file making, note pushing, and passing the buck ethos. That's government. That's just 96.
So what do you want to do?
Well, not only the problem is that this matter, the urgency.
I know that, so I
considered.
can
So
pass the
lordship
order.
will pass out. Lordship will make it savior. Lordship will pass whatever. Because my additional affidavit on bringing in the purposive interpretation is already there. I leave it to your lordship. And because 3 posts were kept.
No, what you are asking for giving a purposive interpretation would have a meaning. This court has to interpret that, and more particularly in view of that recent the judgment you have shown at paragraph 24.
Yes. Well,
How can I give a
show one
purposive
thing,
interpretation?
that the central OM holds the field in areas of
Understood, but
the 3 years has already
But-
been given.
then you have to show me a rule by which the government is bound to follow that. The central OM, in absence of a state OM.
Well, it is enforced office memorandum 25 April 2018 gives that's my case. That's the possible right which is emanating, my right. If at
Which
all.
one?
The annexure respondent 3's annexure 3.
Respondent 3, annexure 3.
820. And OBC is mentioned out there, my lord. Though they are the custodians of the record.
Which
I'm
one?
very
This
sure.
one, the office, the government, after due consideration, have decided that the upper age limit prescribed for entry into so and so under the government of Assam through direct recruitment shall be relaxed by 3 years from the existing so and so. Then, no, this I understand. This is from 25th of April.
Yes.
But for giving a purposive interpretation on the basis of a central government, how can this court do that?
Malad, the central government on reservation policies will not. In fact, this is the state. This is by the personal department. They comply with all directions of the central government vis-a-vis reservation part.
So am I then to hold that as they comply, they are bound till they come up with a notification? Oh, then what is the power under 16.4 left with
No,
them?
Malad, can the government then say that 16.4's power we will not comply with even with the central notification, where the same department is complying with all directions of the Supreme Court on reservation in promotion? All central notification. In fact, the Supreme Court is now taking up. Lordship knows that July day-to-day basis they are taking up this issue on why the in the cadres, why the inadequacy of representation of SC and ST is not being fulfilled or complied with the Jardel Singh 1 and 2. Supreme Court on July is taking up, and they have directed all chief secretaries to be present because the state governments stand. My case has got a relevance now. They have said that they have violated. They have not given them the benefit. Our judgments are not complied. Journal.
No, but the power out here is to be exercised only by the state government for its services.
Well, here I want to say that the power, if their stand is that OBC we never gave it. We gave it only in 18. And in my case, I built up that there was a gap of 50 days. And my thing is that a purposive interpretation for a benefit given to a reserve under the constitution, that gap cannot be said that in vacuum that 55 days will be there. So it's a continuation of the 16 OM, that 18 OM, which argument I developed. Well, assuming we take the argument of the respondents saying that no, we don't have that 3. But I make a categorical submission that the 3 is all along been given. Since Indraswamy 90s, 3 years of OBC is always there. So I basically, since the government is the custodian, I don't believe that the 3 years was never given in Assam. Though they produce the record saying that we give it to the other, the movement, victims of movement and all, OBC was always there. I could not lay hand on.
So
that
should we
person.
ask the government to file an affidavit that
Yes,
they
my
have
lord,
not given?
because the lordship, this was the thing. your
Let the
lordship-
government file it. Once the government files
files
it,
it, let the personal
No, our
commissioner
affidavit is
give a
there.
note
no.
that no benefit.
That there was, you see, in 2016, you had given 3S in respect to SC, ST, and other persons who have been given reservations earlier. Now, Mr. Das has developed an argument that look here, that other persons who have been given includes also the OBC, which upon directions being passed by this court, you have produced some office memorandum, personal notes, all these aspects you have produced. But to totally or nullify that aspect, this court, I think it would be better that you should put it on affidavit that there is no other document to that effect for OBC. Because it is only on verbal instructions you are bringing it.
No, my lord, in our affidavit, we have stated earlier, what is he claiming, my lord? Earlier, we are not giving.
My lord, in their affidavit, they categorically make a statement, there is no benefit to the OBC, oblivious of the fact that the advertisement which they give specifically
Yes.
talks about OBC reservation. If an
paragraph
OBC
5
reservation is there, 3 posts are kept. Is it not that these reserved people will not get the benefit which is being got by people throughout the country? Is it that Assam stands on a different footing? Page 16 of the our advertisement, writ petition talks about the advertisement. Reservation as part a government from government against total.
No, where is that particular document for this 2016 one? Where is that?
No, we have stated.
Yes.
No, there is a 2016.
Yes,
This
yes.
one, yes. The scheduled caste, scheduled tribes, and
Yes.
all other categories of candidates who have already been enjoying the relaxation in upper. You see, what you are submitting is a reservation. Reservation is there is no question. But here it says that SC, ST, and other categories of candidates who have been enjoying the benefit.
Yes.
Not on a reservation, not on the basis. SC is they have categorically mentioned, ST they have mentioned, and other categories of candidates who have been enjoying the relaxation.
Yes, the relaxation is a part of the reservation because the Jitendra Singh's case clearly says that these are basically to give them to the level playing field, and so they can come up. You lessen the marks, you lessen the age, you remove the fee part, then they come in. To bring them at par and then they compete. To bring a level playing field with the general because they can't, because of their educational and social backwardness.
Like in our affidavit,
Para
paragraph 5
39 of Jitendra Singh's case.
That is there, but for that a reservation. But reservation, are you
Include-
saying that the age relaxation is a part of the reservation?
Yes, well, this is a part of this. It was one in 700 and
Meaning thereby that the person, that a category of persons, if it is reserved or
Yes.
under the constitution,
yes.
then
will
they would
get-
be automatically on the basis of reservation entitled to age relaxation.
No, because
That is too far-fetched.
Two different things,
exemption, concession.
I'm coming in 5
Yes,
minutes.
Yes.
For Lordship presume.
Yes.
May I make a small submission?
Yes.
The matter, item number 3 to 12 has been fixed at 2 o'clock, Lordship. I have an online submission in the Supreme Court, Lordship, in a lottery matter. Could it be taken on Monday, Lordship? And my assisting counsel, Dean Nath, he is also out of session because of his wedding in his family. On Monday, Lord.
You've
The other side is
filed the affidavit.
by Monday, it will be little bit difficult. By Wednesday, we will file the affidavit. Because 3 days are holiday. If it is on Wednesday, no difficult. Or Thursday, we will file it by Wednesday. On Thursday, the matter may be taken.
Thursday, Friday, I have some difficulty. Can it be on Wednesday?
Mr. Advocate General, let me just finish up this.
I'm in another part matter at 12:30, Lordship. That matter is fixed at 12. My colleague will be here, Ardhar will be here.
Now, the thing is, what this court is worried about is under what power you are exercising for the purpose of seizing as well as arresting those people.
Arresting is not there, seizing is there, seizing power is there. I'll punish it.
What is the power for to seize?
Yes, seizing power is there, Lordship. The other day it was a full-length hearing. After that, the Honorable Court passed the interim order rejecting their claim.
No, the court did not reject it. The court said, you see, the
On Monday, Lordship, I'll make my
Mr.
submission
No,
today.
Mr. Advocate General, the thing is this. What interim order he is asking is for stay.
The interim order was
not
already rejected on that day. On that day,
On
it
say
was
that
a
I am
full-length
not
hearing for
inclined
3
to
hours.
pass an interim order at this stage.
No. At this stage, I have seen that order. If Lordship is going to take a further hearing on interim order, where is their application? Let them file an application for modification of this order.
It says at this stage.
At this stage, fine.
So on that day,
What is the change of situation from that day till today? There is no change of situation.
No, they are saying out here that you are trying to arrest them.
No, absolutely incorrect. Where is that fact?
Not
Let
arresting.
it come through an affidavit.
In fact, 5 cases we have filed.
Lordship just saying will not do. Let them come with an affidavit because our officers are not arresting anybody.
Is sufficient, not arresting, seizing, and no
Seizing
instruction
power
which
is
was-
there.
which has given by my client. We come to this court. We have already filed.
Where is that affidavit? I have to see it.
5 cases have been filed. Seizing, not arresting.
Let them file that affidavit, bringing the facts before this honorable court. We'll take appropriate instructions. Or if they are in such a hurry, and if this honorable court also wants to hear it at the earliest, we can file by 10:30 the affidavit on Monday. Let the matter be taken up at 2 o'clock on Monday. First, they have to place the facts. We are not arresting anybody. We are not taking any coercive action. Everybody is hiding, Lordship. Their goods are stacked in some godowns. They are not being able to bring it out. That is the problem. Once, if they get any of that liberal order from this honorable, immediately they will start selling off to the detrimental to the interest of the cottage industry workers.
Well, we will give an
The Supreme Court is very well
the
clear,
matter is
Lordship.
decided. We
I'll
will
place
not.
the judgment, Lordship, on Monday. Lordship may dispose of the whole case. Why interim order? If we have done anything illegal, which is not permitted in law, Lordship will set aside our notification as well as whatever action we have taken. This issue was settled way back in 1993 by the Supreme Court.
To that effect?
To the effect that cottage in this sadar, mekhala, all these things are protected. No power loom can produce this kind of items. And their affidavit says that they are producing in it power loom. These are protected items for cottage industry throughout the country. This is a central legislation.
Supreme Court has also said
They will have to overcome that Constitution bench judgment first.
No, yes, my lord. That Constitution bench judgment.
Today, our Lordship is not hearing. That's why this is my limited submission. That adjournment.
My lord, they want to file an affidavit. We cannot have any grievance. In fact, on the last occasion, my interim prayer was rejected on the ground for the time being that they have to file the affidavit because of the urgency, where I made a prayer for seizure. Seizure power was made. Today, your lordship has rightly said, we'll give an undertaking during the proceeding. Well, we cannot stop the government from giving an affidavit, but we will give an undertaking. We will not do anything till the time the matter is finally decided, but they will have to give an undertaking that they will not take coercive action. That lordship which has indicated that is the proper order. We don't want that simply on the ground that we have kept something in the godown. And in fact, on the last occasion, a submission was made that we are all unscrupulous persons, businessmen. Well, if that unscrupulous ground is taken, it's good for me, my lord. So what I pray, we will not do it. We know our discipline, we will advise our client within the law, confines of law. At least I assure your lordship. Your lordship has rightly indicated that we will give an undertaking till the matter is decided. Finally, we will not sell or whatever. We'll comply with the government's order, but they will not take up coercive action. Because we also have a right as a citizen to approach this court. Because our ground is that it's not regulatory, it's becoming prohibitive.
One more
We
submission.
do one thing.
Yes, Lordship.
We fixed the matter on 16th May.
Well, the only problem is that 16 May, from 10th May, I'll be on.
But then ask somebody else, because if you want it,
Well,
you
I have
want
some,
an order, otherwise
urgent. Well, one thing I can do it next week. Rightly, my learned Advocate General has rightly said. Can it be on Wednesday?
Agreeing.
Because anyway,
No. You see, Monday, I'm telling you, Monday, Wednesday, and Friday is for pension suspension matters. I don't take up all these matters on the other days.
Then your Lordship will fix
So
up.
it has to be either on Tuesday or Thursday, these matters,
Well,
otherwise.
then
So
Thursday, Lordship.
can it be on the 38th, where they will give their affidavit, because they also have to be given
30?
that time. 38th of May, where they will give their, because they are wanting some time. At 10:30, they have taken my consent also. I have given a consent.
In fact,
So
that
let
was the
them-
understanding, Lordship.
Yes, that is there. So, but
No, the understanding, Advocate General, between you does not
No,
work with this.
not understanding, not with me, Lordship.
That doesn't work.
No, that
No,
understanding
then
not
if
with
you
me.
are willing to remain till 30th, then what is the problem? I'll give them well time. Then you file your affidavit by 22nd. He files the affidavit reply by 29th,
9th.
and we'll fix it on 30th.
Yes.
Lordship.
Only this part may be given.
No,
of course.
nothing doing. I gave you the opportunity till on 11th. You don't want it. You don't
Well,
want it on
11th,
16th. You don't want it on 18th.
Lordship has fixed it on.
I'm not going to grant an order. If you have any difficulties out there, the petitioners are at liberty to engage some other person.
Well, my Mr. He'll be there.
Fantastic. Then we will have it on 16th.
Yes,
You
yes,
file your affidavit by 11th and you file your reply by 15th.
Yes.
Heard Mr. D.K. Das, the learned counsel, appearing on behalf of the petitioner, and Mr. D. the learned Advocate General, assisted by Mr. Ardhar, appears on behalf of the state respondents. This court, by the order dated, what is the last date?
4th of 4th April. 4 April.
4-4.
By the order dated 4/4/2023, and directed the state respondents to file their affidavit by today. However, on account of certain difficulties, the said affidavit could not be filed. However, it has been submitted that the said affidavit would be filed by 11th of May by the state respondents. That the matter be listed on 16th of May. The petitioner is so advised to be at liberty to file their reply by 15th of May.
Highly object.
Constitution.
My next limb of argument is that the concession, relaxation, and exemptions, this fall within the larger concept of reservation. And in fact, I'll take your Lordship to paragraph 743 of the Indra Swani judgment, where a similar case of 1976 Thomas case was being referred, where relaxation was sought for, because these persons were not getting the promotion, stagnating. They could not, because they belong to the reserve. The Supreme Court relaxed it, and in fact, the Thomas case is important for the simple reason that for the first time the Supreme Court held that reservation is a mode of achieving equality. Till earlier, it was held to be exception. Lordship will come to page 743, para 743 of Indra Swani. 743. Can I read?
Yes.
The question then arises whether clause 4 of 16 is exhaustive of the topic of reservation in favor of backward classes. Before we answer this question, it is well to examine the meaning and content of the expression reservation. Its meaning has to be ascertained having regard to the context in which it occurs. The relevant words are any provision for the reservation of appointments or posts, The question is whether the said word contemplate only one form of provision, namely reservation simpliciter, or do they take in other forms of special reservations, provisions like preferences, concessions, and exemption. In our opinion, reservation is the highest form of special provisions, while preference, concession, and exemptions are lesser forms. The constitutional scheme and context of Article 16.4 induces us to take the view that the larger concept of reservation takes within its sweep all supplemental and ancillary provisions, as also lesser types of special provisions like exemptions, concessions, and relaxation, consistent, no doubt, with the requirement of maintenance of efficiency. The admonition of 335. The several concession, exemptions, and other measures issued by the Railway Administration and notice in Karmachari Singh's case are instances of supplemental, incidental, and ancillary provision made with a view to make the main provision of the reservation effective. That is to ensure that the members of the reserve class fully avail of the provisions of reservation in their favor. The types of measures is the one in Thomas. There were no provision for reservation in favor of SC/ST in the matter of promotion to the category of upper division clerks. Certain tests were required to be passed before a lower division clerk could be promoted as upper division clerk. At a large number of lower division clerks belonging to the SC/ST were not being able to pass this test, with the result that they were stagnating in the category of LDC. Rule 13A was accordingly made, empowering the government to grant exemption to the members of the SC/ST from passing those tests, and the government did exempt them, not absolutely, but only for a limited purpose. This provision for exemption was a lesser form of special treatment than the reservation. There is no reason why such a special provision could not be held to be included within the larger concept of reservation. It is in this context that the words any provision for the reservation of appointments and posts assume significance. The word any and the associated word must be given their due meaning. They are not mere surplusage. It is true that in Thomas, it was assumed by the majority that clause 4 permits only one form of provision, namely reservation of appointment post, and that if any concession or exemption are to be extended to backward class, it can be done only under 1 of 16. In fact, the argument of the writ petitioner who succeeded before the High Court was that the only type of provision that the state can make in favor of the backward class is reservation of appointment provided by clause 4, and that the same clause does not contemplate or permit granting of exemptions or concessions to the backward class. This argument was accepted by the Kerala High Court. This court, however, by a majority, reversed the stand taken by the Kerala High Court, holding that such exemptions, concessions can be extended under Article 16(1). Beg, who joined the majority in upholding the validity, rested his opinion on a different basis. According to him, the exemption provided by the impugn notification was indeed a kind of reservation, as was warranted by and relatable to clause 4 of 16. This was because, according to the learned judge, clause 4 was exhaustive of the provision that can be made in favor of the backward class in the matter of employment. We are inclined to agree with the view taken by Beg for the reason given herein above. In our opinion, therefore, where the state finds it necessary for the purpose of giving full effect to the provision of reservation to provide certain exemption, concessions, or preference to members of the backward class, it can extend the same under clause 4 itself. In other words, all supplemental and ancillary provision to ensure full availment of provisions for reservation can be provided as a part of concept of reservation itself. Similarly, in a given situation, the state may think that in the case of a particular backward class, it is not necessary to provide reservation for appointments and posts, and that it will be sufficient if such preference or concession is provided in their favor. This can be done under clause 4 itself. In this sense, clause 4 is exhaustive of the special provision that can be made in favor of the backward classes. Backward classes, having been classified by the Constitution itself, is a class deserving special treatment, and Constitution having itself
No,
specified.
Mr. Das, I understand it. The reservation will include many aspects.
Yes.
There's no quarrel with that proposition. But the question is, if we hold that merely because the reservation is already given to OBC, it will also include the relaxation from the date the reservation has been given then wouldn't it Article 416(4) be authorized, taking into account that it is not necessary? The moment you are reserving, the relaxation comes back from that date itself. Then
No, our case is that the concession which was given, they are denying it. They are saying that this concession was never there. It came only in 18. The entire problem is arising because,
no,
because on
they
the-
are saying that you look at that as regards the other people
yeah,
which have been mentioned in the notification of 2016.
yes,
Did not include any OBC because this is not a case of reservation which have been mentioned. They specifically mentioned SC, ST, and other people who were enjoying on the benefits
yes.
or who were enjoying the specific words you used here is at page.
Existing benefits, other categories who had already been enjoying relaxation.
Enjoying the relaxation.
Yes, well,
So moment that is there, as per them, the question of, as per them, OBC never enjoyed any relaxation earlier.
Yes.
That is the specific statement. That is why I wanted that they should put it on way of an affidavit
Yes.
instead of producing these documents.
Yes.
Then once it is being put on record by way of an affidavit,
yes,
then we are rest assured that there is nothing. Because you see, when it is put by way of an affidavit, it is done on the basis of an authority. It is based on a responsibility, a sense of responsibility. If it is tomorrow, they may say that yes, there was anything, but that person concerned while informing Mr. T.C. Sutia did not inform him.
yes.
I think the sense of responsibility demands that they should put it on affidavit. Like that day in a matter pertaining to the FRSR. What was happening out here, there were 3 books. One was an FRSR done by this one, by ALA,
Yes.
Assam Law House. There is one by Mr. Diwan.
Yes, yes.
One is by Mr. Some publication, some skyscraper skyline publication. That was earlier the DVD.
Yes.
Now that publication of FRSR has been forwarded by Justice Indira Shah and stated as applicable to the state of Assam. Now, what they have done in those 2 FRSRs, that is by Mr. Diwan and by the skyscraper, they have incorporated everything which is there in the central FRSR and did it. Now, while I was hearing, one side was saying that we are only having 56 A, B, and C. But in the other side, while showing the other book, was showing that it is 56 A to J. Because that is also a book and it has been, more particularly, it has been endorsed by Justice Indra Shah saying that it is applicable to the state of Assam. And I called up this person concerned as regards the personal secretary to that effect, and from the personnel department, and asked them to put it on affidavit. They put it on affidavit that they only follow this one, not the others, for the state of Assam. And that I have recorded it on the basis of that. Then for all purpose, there is a sense of responsibility because tomorrow they may point a finger upon with Mr. T. that he did not place on the record.
Sanctity is there. Lordship, then let them find it.
No, but in fact, Lordship, kindly see our affidavit paragraph 5, second paragraph.
Your affidavit response number?
3. We have stated here,
Number
response number 3, that is the
Yes.
Justice Secretary. Yes,
Second paragraph.
it is seen from the writ petition paragraph 6 that petitioners crossed the age of 43 years on 1/1/2018. For OBC and MOBC candidates, there was no other existing relaxation in upper age for entry in government job at the time of this advertisement. The contention of the petitioners that the other backward classes community has been availing 3 years of upper age relaxation in appointment process since long is not true. The said benefits of 3 years regarding upper age relaxation given to OBC and MOBC candidates came into force only 25th of April 2018. That is official memorandum dated so and so. As on 1/1.
So it is already there.
Yes, already we have.
So if it is there already, it's okay. I'll reserve the judgment.
Lordship, I have submitted 3 cases, my lord. That is malad, and Swahani case also malad, it has been mentioned malad in paragraph 859. An executive order making a provision under Article 16(4) is enforceable the moment it is made and issued.
Which one?
Paragraph 859, Swahani case one. B, 1 clause 1B. An executive order making a provision under Article 16(4) is enforceable the moment it is made and issued. See para 738 and 40.
Which judgment you are referring to?
Swahani, Indus Swahani case.
Indus one.
Yeah.
Okay.
Paragraph 11 is 37, 38. It is mentioned all of these things. It should be of the death. So they are claiming that 25th of
You
April
have given, Mr. Tishuti, you have given K. Manjusri.
three Manjushri
And then one Asut Kolita,
Kalita and also Malad
Chandan Deka.
Chandan Deka. Yes.
And Mr. Das, you have given?
Yeah, Malad, I have given Indraswani, Jiten, Chalameshwar, Honorable Justice, 2015.
Then N.N. Thomas, which paragraph? N.N. Thomas, which paragraph?
N.N. Thomas. Yes. Indus 743.
But in paragraph number 754
Yes,
of Indus Wani, it deals with N.N. Thomas?
yes, N.N. Thomas, because that is the classic case where from 1950 the Supreme Court holding that it's an 16.1 is an exception, 16.4 is an exception of 61 was done away, and they said it's a mode of achieving equality.
So why is it necessary?
Well, to harp the point that these concessions which are there, because I was harping on the second limb of argument that the gap which the government is saying that you get it only from that day. I say that at 16 and 80 there's a gap part that vacuum could not have if a purposive interpretation is there. That was my limb of argument, which I brought it in my additional affidavit. In fact, I have another judgment which I referred to Jitendra Singh's case, where the entire concept of concession and exemptions were elaborately decided at 2010 3 SCC 119. Paragraph 39 in Manu Patra's 2010 3 SCC 119, paragraph 39, which refers to also Indra Swani's paragraph 743.
59?
Paragraph 39.
Mr. Vedera, you have given me this one, Jitendra Kumar Singh, 2010.
Yes.
Which is the paragraph for that?
39 of
Manu Patra.
No, who gave me this? Yeah, SCC.
We have submitted.
It is given by you only.
No.
You have only given this, Mr. H. Betala, 27/4/2023, 2010 3 SCC 119, 1972
10
2
3
SCC.
SCC 119.
Yeah.
He's saying that this is the earlier copy. Today he has given Manu Patra.
Okay, give me what is the paragraph?
Paragraph 39 of it.
39? What is that paragraph 30? Mr. Das, you are looking into the SCC?
No, I'm looking into Manu Patra.
Yes, paragraph 39, which one? It starts with?
In view of the aforesaid facts.
Okay.
In view of the aforesaid facts.
Yes.
It refers to paragraph 743 of Indra Swani also.
All candidates had to appear in the same written test and face the same interview.
In fact, it refers to Article 38, the Directive Principles of State Policy, which talks about the disadvantage to the candidates belonging to the socially and educational background.
So you are only referring to 39.
Yes.
Since somebody referred to this 1992 supplementary 3 SCC 210.
Indraswamy.
That is Indraswamy 5 judges.
9 judges, Lordship.
No, this is 5 judges.
This is a 9 judges. This is
3 of
still
us
holding
sitting
the
as a
My Lord, in fact, your Lordship can take up 2 judgments where this relaxation was decided by the Supreme Court. Those are very famous case, 1981 1 SCC 246.
Where do I get
Akhil
it?
Bharatiya Shoshit Karmachari. And 1981 1 SCC 246, because in para 743 these 2 very important judgments are referred.
Relating to?
Related to concession part, relaxation. Thomas case was also relating to 1976 to SCC 310. They had an entire purposive interpretation, what I was referring to in my additional affidavit finds place. Because in fact, 1976, and they never thought that it was an exception to, because 16.1 talks about the rights to the general, 16.4 to the reserve. They thought that 16.4 was always an exception to 61. Oblivious of the fact that ultimately you bring a people to the mainstream, you cannot bring in because of their disadvantage. You give them level playing field, take it to a level, and then they leave it. Because now, as your Lordship knows, that in the IITs, the new statistics are showing that the persons belonging to the reserve, they are doing excellent in the IIT, and they have given up the younger generation because they are getting on merit. So basically, they are now competing as a member of the unreserved. That was the main purpose of reservation. You bring it to a level, because in America, they call it race. In India, we call it caste. Caste is a factor. It's a social construct, so it remains. So that's the, these 2 cases will help your Lordship. The detailed law, in fact, these 2 cases are, especially the Thomas case of Krishna is the classica son, still holding the field. That is not an exception, it's a part of 16.1. The 2 communities, it's a part, it's nothing, it's a mode of achieving equality, because you are giving benefit to them. It's not that you are discriminating them, because constitution is permissible. Still,
No, yeah, that is what if you see in those other journals and judgments
yes,
also.
yes.
And I think B.V. Pavitra.
Yes.
Very nicely explained by
Very
Justice
nicely. In
Chandrasud.
fact, Viveka Pavitra said it is not anti-meritarian.
Yes.
Because if you bring in merit part, in fact, at a point of time, I think Article 335 maintenance of efficiency will have to go, because a little bit of racist, as soon as you talk about merit, racism comes in. Honorable Justice Chandrachud's judgment. He
So while
elaborately
he was saying that in fact 16.4 is nothing but it's in aid to give benefit under 16.1.
Yes, and that started from Thomas case. This is the first case. Till Thomas, the Supreme Court never talked about it. In fact, the dissenting judgment of Justice, I think, Rao, yes, in an earlier case, his view was not considered. Rangachari, or I forgot the Devadasan's case, 60s, his view was taken. Just like Manaka Gandhi, ADM Jabalpur minority judgment became the majority judgment of Justice Khanna. That's the, so these 2 judgments, say 81 1 SCC 246 and 76 2 SCC 310. Well, 81 1 SCC 246. That the entire concept is there. 81 1 SCC 246 and 76 2 SCC 310.
But that you have already given,
Yes.
N.M. Thomas.
Yes, that finds place in paragraph 743 of Indraswamy.
N.M. Thomas, which paragraph you are referring to?
Malad, here,
And that to whose opinion?
Malad, it will be the majority opinion, because basically the majority, Krishna's opinion was there. Justice Matthew, Chief Justice Matthew, Krishna and Fazal Ali. It is in the next part, 694 page, where it talks about.
Majority opinion was of Justice Ray.
Yes, Ray, Matthew, and Krishna and Fazal Ali.
Concurring was Matthew.
Yes.
But which paragraph you are referring to?
In fact, the paragraph is not there. In fact, I'll keep the paragraph. Well, we'll give it. We'll indicate the paragraph. They will-
Paragraph 46. All legitimate methods are available for equality of opportunity in service under Article 16.1. Article 16.1 is affirmative, whereas Article 14 is negative in language. Article 16.4 indicates one of the methods of achieving equality embodied in Article 16.1. Article 16.1 using the expression equality makes it relatable to all matters of employment, from employment to promotion and termination to the payment of pension and gratuity. From the point of view of differential treatment is given to a member of the man.
in fact,
But whatever may be, these judgments which you have referred to, maybe on the question as regards Article 16.4 and up. But does it say in any manner that when a notification is issued, because this otherwise it doesn't help you, if a notification is issued of age relaxation, and as age relaxation happens to be a part of the reservation, it dates back to the date of reservation. If it doesn't, how does it help you?
it dates back to the
Date of reservation. Otherwise, it doesn't help you. This will help you only if, as could be seen from Indraswani, reservation includes relaxation,
concession exemption.
and if a relaxation is given and there is a person who is reserved, it dates back to the date of reservation. If it does not, and it operates only prospectively from the date of the relaxation being given on the 16.4, thereby, yeah, then how does it help you with these judgments?
Two are different things. Age relaxation is from time to time government is relaxing, but reservation is already there. 50%, 10%,
And
60%.
another aspect, your lordship will see, lordship, that in the vacuum, the central rule since 93, Indus 1 was already in operation.
Understood, but that is too hard to say that, because that would be
Does it
asking the state, or this court had presuming that in absence of the state rule, the central rule will apply. That would have a far-reaching consequences with that
But
observance.
one thing, does it mean that from Indraswani, when the Assam government is complying with all the directions of the Supreme Court on the SC, ST were getting 5 years, is it that the OBC were left out all along?
The OBC were given the other reservations of bringing them within the fold of reservations and giving the benefit under 16.1. But the enabling provision as regards age relaxation was not given.
Because what has happened, it is it can be logically presumed that if SC will be.
Now tell me, when did the central government notification come?
It was all in the 90s after Indus 1.
Okay. Now what happened in the meantime after Indraswani?
What after?
You see, the central government notification came in
It is on 25th January 1995.
1995.
Yes, we have given it.
95.
Yes.
Now, what happened from 91 to 95? What was the state of affairs?
No, the state of affairs was like this. The Indraswani's case said that there can be recruitment, reservation in recruitment, no promotion. But the Supreme Court added that Parliament can take a call and we give 5 years. That 5 years period, you do it. And
understood. But what happened to age relaxation during this period of 5 years?
We can only presume that from January.
Can on the basis of presumption, I issue a writ of mandamus.
25th January 1995, the only after Indraswani's case, Because Indra Swani's case was not about SC/ST reservation, it was about OBC.
Understood.
27%
No, I am
was given.
asking you therefore,
Yes.
Indoswani happened in 1991.
Yes,
This office memorandum of age relaxation came in 1995.
yes.
What happened during these 4 years? Whether any relaxation was given?
That
No, if it
in 1980, the Assam government started giving the benefit of relaxing.
age relaxation.
Yes. Relaxation of age.
This is not for OBC, everybody.
Yes.
This is for everybody. But what do you say about 2? The relaxation is to be granted under the powers conferred in the notification by the appointing authority.
Yes.
Then- Now the appointing authority categorically says that there was nothing as regards OBC.
Well, it adds also, in case of appointment made by the governor, the appropriate administrative department will be responsible for granting the relaxation in case which appointment is made by the head of the department, such head will grant the relaxation. And if it is done through the APSC, that is 4.
Then the APSC has to be consulted.
Yes.
This is for everybody.
Yes.
If that be so, then this particular, if you have to rely on this, then 2016, 18,
Yes.
nothing has any value. Everybody has to be given. Heard Mr. D.K. Das, the learned counsel appearing on behalf of the petitioner. Mr. T.C. Suti appears on behalf of
Respondent Malot
which department?
Malot the government, but 110(3) and 1 3 Malot.
Personnel department.
Yes. Chief Secretary and Personnel Department.
On behalf of the
One and 3.
respondent number 1 and 3.
He is appearing for
Ms.
respondent number
M.M. Kotoki appears for the respondent number 2.
Yes, by PJ1.
Mr. P.P. Dotto appears for the respondent number 4, 5, and 6. Hearing complete, judgment reserved.
My lord, I add to one more case, my lord. 1980 supplementary SCC 524 regarding, my lord, I am giving it to the citation, my lord.
For what?
For regarding, my lord, selection committee does not have a power to lay down any norm in the selection committee has no right.
Huh?
My lord, selection committee does not have inherent power to lay down norms for selection. That is the case, my lord. Because age they cannot do it, my lord, until unless it is elected by the government. Selection committee. That case in 1980 supplementary.
How does it help you?
It is helping my lord because otherwise I am submitting it because my lord is support of me because electoral committee cannot help.
Mr.
Anyhow,
Speaker,
it's
kindly
not
appreciate one thing. This matter has transgressed into a few in a very other area, but the pure and simple cases that the notification issued in 2018, can this court by a mandamus direct it to be given effect to from the date of the selection?
No man. It cannot.
Why should I go into all other?
Yes, yes. Simple.
But anyways, the question of legitimate expectation is also there. So, but a prima facie, Mr. Das, what I propose to do, I may change, I don't know, but prima facie, I don't feel that there is anything, any writ can be issued, but I think you have a legitimate expectation. And on the basis of that, I can ask you to submit a representation in a proper manner, and their authority can take into account the same, including the various aspects which I'll mention, and then decide.
That will suffice.
Well, some candidates are supposed to be not qualified. Qualified condition is that they are qualified, their age is not qualified. Some candidates are they are qualified, but age is okay, but not qualified. They are not before your lordship because they know we are not qualified. We are not second class master degree. That's why they did not apply. They applied for.
Well, can my learned friend know that why they have not come?
Yes.
No,
I am
Mr.
before this
Sutia,
court.
I am not passing an order that you allow them.
Yeah.
I am
I'm also
putting
not
the ball in your court only. Really allowing
They'll
you.
definitely take a sympathetic view.
Huh?
Government is always supposed to be a model employer. How they act in my case will come to know.
All the problems arose because of allowing you to sit in the exam.
Since 18 years.
Yes, yes.
The petitioners are having that legitimate expectation. And they know the limitation. I have told them also. We also have to be within the confines of law. But that
Because the other aspect would have, therefore, the main crux of the issue is this.
yes, right.
Lordship, in judgment, my senior name may also be recorded.
Whose name?
TJ Mohan.
Mr. Datta,
Lordship, he
kindly
appeared
appreciate
earlier,
one thing.
On earlier occasion, he addressed.
Earlier occasion, didn't I put Mr. TJ Mohan's name? I put.
Yes,
But when he has not appeared, why should I put his name?
Obliged, my lord.
I know 17 to 26.
He appeared, Lordship.
Yes,
He appeared, Lordship.
After the conclusion of hearing.
And number 17 to
I may put his name out there that because of his name, the matter has been delayed. That you want, I can put it.
17 to 26. Sorry. 70 to 40.
Yes, Mr. P.N. Sharma.
In this matter, lastly, the SSA is also necessary party. SSA, they are under SSA, contractual employee under SSA law.
Hmm?
They have been engaged on contract by the Sarva Shiksha Abhijan Mission. And it appears that they have filed affidavit. If they want to proceed with the hearing, lordship, they can, but in our part, elementary education department part, we will.
So we will hold that the SSA has no representation. Matter ends.
Lordship.
We will hold that the SSA has no representation. We'll hear the petitioners and dispose of. Isn't it, Mr. Bora? Okay. You start, the petitioner start.
Our submission, we will be giving some other time.
No, nothing doing you. The moment I want him and I find that the SSA I'm not getting representation, on the basis I'm convinced with the petitioner, I'll pass the order. Madam is sitting out here for taking the dictation. Yes, Mr. Goswami. We will accommodate by taking it at 2.
Actually, my
I'm allowed to submit, my lord, these matters have been listed after a very long time. The matters are for provincial regularization of service of the petitioner. Number of cases are there, but they're all uniformly situated by different petitions. These are TAT teachers. They were appointed in the year 2012. And since then, my lord, they have been continuing service. There have been ups and downs in between. In one such situation, we have preferred these petitions, my lord.
They were appointed by whom?
Appointed by to the regular, there is a selection, but under
By
SSA,
appointed by whom?
under SSA, my
SSA has all appointments under contractual.
Yes, on the contract.
my lord.
Then
Lordship, our case is there.
case of regularization.
No, Lord. We are, by an advertisement, we have been appointed. We are given regular pay scale. We are given.
But in the advertisement, what is the advertisement say?
Lordship,
That-
but
that
there
you
is
know,
a
sir, that you know.
there is a clause that we cannot claim regularity. But we are not claiming regularization. We are claiming absorption into a vacant post. On
Of the
basis
government?
Of the government
How?
on the basis of some statutory provisions, Lordship. As per the RTA.
You see, the absorption into a vacant post of the government can only arise upon a government taking a decision that, look here, we are very considerate about the persons whom Mr. Bora is representing, and as such, as a policy decision, we will regularize them and bring them within the fold of the. If this court, in view of Uma Devi, can this court, in view of the district, the
Karnataka.
not the Karnataka, the other one, the J&K, and the High Court of J&K versus District Court of Bandipora, that is another judgment. Do so? No. Matter ends.
The only thing, my lord, the
It is
government.
absolutely within the area of the domain of the state government to do so.
My lord,
And the state government is you. Why you are bringing the SSA? SSA have no business.
Lordship, otherwise, their appointment is governed by the contract.
Understood? So, for you,
Lordship,
their main relief
Lordship,
is with you.
Lordship. Main relief.
They have no relief with the SSA. SSA has been happy, appointed them and all. Now they don't want to remain with SSA. They want to come within your fold.
exactly.
That's it. But how can this court direct in view of Uma Devi?
Yes, Lordship. In
But it
Uma
is-
Devi also,
it is,
in
Lordship.
para 53, there is a concession.
Para 53 is not a case where these are case of illegal appointment, the irregular appointments.
Lordship,
Those irregular appointments were not to be disturbed as they have been working out there. And however, not on the basis of any orders being passed by court. That is the order of 53.
Yes, Lordship, at para 52, if I am correct, there is another exception in Uma Devi that if the statutory provisions provide for it, court can direct absorption.
Fantastic. Then obviously, if a statute
Lordship will
provides
satisfy your
that
Lordship
if
on the
a
next
person is working in SSA, they can be brought within the ambit of this, then obviously a writ
Yes.
can be issued.
Yes, Lordship.
Yes.
We
We'll take it up
satisfy
at
on-
2.
Lordship, for today, Lordship.
No. These are matters not to be adjourned at all.
Lordship,
I don't give adjournment unless you make out of a case that there is a case for adjournment. Case for adjournment is a case where your case has to be better than a case for a writ of mandamus. Yes, I'm coming.
our case,
Figures out there. Just to ascertain that my stenographer has correctly put the figures. Do you have the records still?
Today, Lordship, today I have not brought that.
No, but do you have the records?
Calcutta record has been sent by Guwahati record is there.
Guwahati means which one? The 2017?
2015. Lordship,
In fact, there was a photocopy also made. I don't know whether it was
Lordship,
kept
the
in the
entire record has
records.
been taken by the officer.
No.
Yes, in
The
that.
Calcutta record,
Yes, there was a
a
photocopy.
photocopy also was made. I
Yes,
don't know, I kept it in the record or not. I've seen. I'll have to
Probably
look.
it has been returned back. Lordship.
Anyways, those facts, just for example, those percentage which have been mentioned would be wrong on the part to get the percentage wrongly reflected. No?
Lordship.
Just for example, I have mentioned about 2013 14, the percentage is 1.04. I hope he has rightly put it out there as 1.04 and not 1.05. That is the way. Actually, while dictating it, I didn't think about it, but while correcting it, there were so many facts and figures.
I can get back the record.
That will take a long time, no?
Monday.
Monday, if you can get hold.
I'll instruct
You just get hold of it so that I can just put the correct
2017 note.
17 and 15 also, because
15 is
15,
with me, Lord.
15 also and 17 also. You just get hold of the record, so I just can peruse the.
Okay, Lord. On Monday I'll provide.
Yeah.
Much.
My lord, if your lordship is taking up this series, my lord, I appear in 3 of these cases, my lord. Item 28, 29, and 36, my lord. Now, as the present status is, my lord, as we know, my lord, that many of these petitioners have also been regularized in the meantime by stand taken by the government from time to time. Initially, they were given the same salary they were getting, all right, my lord. Then, my lord, thereafter, my lord, they have come out with a policy of, my lord, regularizing the services on the basis of, my lord, as we know, my lord, that the particular institution has to receive 2 A+ rankings, my lord, in Gunotsam. So on that basis, many of these people have been regularized, but we don't have the figures, man. And these matters have been listed a long time. If your lordship will kindly allow us some time, my lord, the status we will know, and then, my lord, your lordship can dispose of. And beside that, my lord, in 2 of my cases, my lord, I'm extremely sorry, typographical errors, my lord, 2 IAs are there for correction of their names or the schools, man. In 2 of the cases, not 3, man. So, if your lordship allows that, my lord, I've given the detail. In item, my lord, 28 and 29, my lord.
Now, who is there in WPC number 5824? Now, Mr. Bora, tell me one thing. How is this repetition and effective read be maintained? You are asking that some post has to be created. How can a post be created without the finance?
Yes, Lord, to finance. Yes, Lord, to finance.
Without the finance being made a party, how do you think about a writ can be issued in this case? Because the finance will have to say that it is required. And more particularly, if you see the rules of Assam rules of more particularly, Rule 10. No department shall, without the previous consultation with the finance department, authorize any order other than the orders issued under the act or rules made thereunder, or pursuant to any general or specific delegation made by the finance department, which involve the addition of posts in public service, or the variation of emoluments of any post, involve the sanction of any allowance or special pay. So, who is going to give you the money for those posts?
Lord will allow us to
Secondly, is each of the repetitioner claim is separate and distinct?
Yes, Lord.
Or if one post is given, one person is regularized, one post is created, it would satisfy all the petitioners?
No, Lord.
Then why the fee of only one person has been paid?
Yes, Lordship. Lordship, now the face matters we file with
No, I am not concerned with the fresh matter. Earlier also that was the law.
law.
Your
Yes,
petition should be, if it was earlier, then now you have done it, that means your petition should be dismissed on that ground.
Lordship will pay it immediately tomorrow.
The deficit court.
And yes,
Where is Mr. R. Gaur Pujari? Can you call him? We make him a party. Itu video connect. Kita read paragraph 26 aloud so that the other petitioners, counsels for the other petitioner.
Lordship,
26.
the principles will have to be formulated bearing in mind the position set out in the above judgment. Regularization is not a source of recruitment, nor is it intended to confer permanency upon appointment, which have been made without following due process envisaged by Article 14 and 16 of the Constitution. Essentially, a scheme for regularization in order to be held valid must be one which is aimed at validating certain irregular appointments, which may have come to be made in a genuine and legitimate administrative exigency. In all such cases, it may be left upon to the court to lift the veil to inquire whether the scheme is aimed at achieving the above objective. Is instrumentalities cannot be permitted to use the window to validate illegal appointments. The second rider must necessarily be placed in debt. The principle, as formulated above, is not meant to create or invest in a temporary or ad hoc employee the right to seek writ commanding state to frame a claim which has been shut out permanently by Uma Devi 3. Ultimately, it would have to be left upon the state and its instrumentalities to consider whether the circumstances warrant such a scheme being formulated. The formulation of such a scheme cannot be accorded the status of an enforceable right. It would perhaps be prudent to leave it to the claimant to establish whether he or she falls within the exception carved out in para 53 and falls within the ambit of a scheme that may be formulated by the state, subject to the riders referred to above. A scheme for regularization could fall within the permissible limits of Uma Devi and we have upheld.
Who has to do it?
Or to the government.
Can I issue a writ?
Lordship,
Then in that judgment itself, just turn few pages before paragraph 10 I spoke.
the issue which arises must be viewed bearing in mind the essence of the judgment of the Constitution Bench in state of Karnataka versus Umadevi and subsequent judgment which followed it. In the judgment of Constitution Bench, the following two issues primarily fail into consideration. The right of employees seeking regularization on the strength of the long and continuous work, the correctness of the direction by courts for regularization of the employees under 226 of the Constitution. This is the tweet.
Further.
The decision of Umadevi 3 dealt firstly with the claimant by temporary employees to be regularized in service on the basis of their long and continuous legitimate acceptation employment under the state and the directive principle. The second salient question, which is the Constitution Bench was called upon to answer, was whether courts would be justified in issuing direction for regularization based on such features such as equality and long spells of service. On both counts, the Constitution Bench held that temporary employees, however, Umadevi 3 is not an authority for proposition that the executive or the legislative cannot frame a scheme for regularization. Umadevi does not denude the state or its instrumentalities for framing a scheme for regularization. In para 53 of the decision, or 53 is put.
So, it is the state who has.
Yes.
And there were two contentions made in Umadevi.
Yes.
First, as to whether the court can direct for regularization.
Yes.
And second, whether the court can direct the state to regularize
Yes.
and formulate a scheme.
Yes.
Both were negated by Umadevi.
Yes.
Only thing is, the state can very well have a scheme for regularization.
Yes.
Then if you read paragraph 26, which I have just placed
Yes.
here, it categorically mandates that it is within the absolute domain of the state to have a regularization.
Under one.
Then what is the role of the court?
Yes, well, Lordship, small window is left by Umadevi. If the statutory, there is some scope in the statutory rules, then Lordship, para 52 of Umadevi only.
What is left? What is there in the statutory rules? Which rules are you speaking about? That those people who are in contractual appointment would be brought within the fold of the state government? Which rules states that?
Yes, Lordship.
Yes.
Where? Lordship, the two things Lordship will decide in this petition. Firstly, whether the state can at all appoint contractually for in primary schools, which is governed by the RTA. Firstly, that. Secondly,
so you want your appointment should go?
No, Lordship.
Then, if I hold tomorrow that the state cannot appoint, your appointment has to go. If you are saying that, obviously the natural corollary is the appointment is bad.
No,
now, can the court thereafter say that all appointments has to be in regular posts? Meaning thereby, this court will be directing that all these appointments has to be in regular posts, which this court can't, because it is within the domain of the state to include them within the purview of the affairs of the state.
Yes. Lordship, Umadevi is only for illegal and irregular appointments. We are perfectly regular.
No, not on illegal or irregular. The question which was there before Umadevi is, can the court under 226 direct regularization, which was negative and said that no, the court cannot. It is paragraph 53 which says that those people who have been working out there without any help of the court's order and have been working, they should not be disturbed what we have held. That is what is paragraph 53. And that has been also explained by this division bench of the Supreme Court. It has been further, many other judgments it have done that.
Yes, Lordship. There is another judgment which Nihal Singh, Lordship, para 53, Lordship.
There also paragraph 53.
Para 53 was that sanction force would not fall from heaven. That was the word used for in that judgment. In Nihal Singh. That state
Now,
has-
in this very judgment, which I placed, I referred to in that state of J&K versus District Court of Bandipora, that one, which I referred to. That judgment also takes care of that and says that Nihal Singh's judgment, which has been given out there, did not take into consideration Uma Devi in this manner. Now, when a Supreme Court categorically explains a constitution bench judgment and says that this is this, they are bound by that. Like I always give an example. Mr. Chaudhary remembers that judgment of you were there on the other side. I was on this side. That is the matter pertaining to India Cement and Kesoram.
Yes, yes, that word.
India Cement was a judgment of 7 judges. The 5 judges of the Supreme Court says that it was the stenographer's devil which had resulted in disorder. And this India Cement judgment was followed all along. And later on, by this paragraph, it categorically says it was a stenographer's devil.
I think in Kesoram industry.
Yes, State of the West Bengal versus Kesoram
Kesoram.
Industries.
5 judges bench.
Yeah. Justice Sinha's
Chief
judgment.
Justice Lahoti headed the bench.
Justice Sinha's judgment.
Sinha, Honorable Justice.
So, now Mr. Borpujari, here what has happened is this. In this batch of writ petitions, these people were appointed on contractual basis by the Sarva Shiksha. Now, Assam Animal Husbandry and Veterinary Department, as well as Sarva Shiksha, as well as PHC are departments where the councils are very difficult to find. So, be that as it may, Mr. Sharma is there. So, with his help, I was taking up the matter. Now, they claim that they should be regularized and brought within the fold of the state government. Meaning thereby, the finance has to approve. Finance is not a party.
In 2 of the matters, finance have been implemented.
The others not. 2 matters.
We may be allowed to.
No, I will make it. I will make it. Don't worry. These small things I will do it. Don't need to file IA for it. So we will make this finance party. That is why I call it.
Yes.
So you serve copies.
Yes.
Deficit code.
Yes, definitely.
Also, I have placed one notification issued by the government insofar as the job security is concerned, Lordship.
In pursuance to the decision of the Iman on Iman to provide service benefits.
If they come under the purview of the notification, Lordship.
So everything has been given 2020 except pension. So your only case is of pension now. Everything else has been given. Why not the pension? Why they are not brought within the ambit of this pension? Obviously, they can't be brought under the pension because the pension, as per the particular definition in section 2A as amended, says that they have to be appointed to permanent and substantive post. Permanent and in a permanent and substantive capacity to permanent and temporary posts. in pensionable establishments. These are the three requirements. Now they are post or not post pension. Then what else they will get upon retirement? Hmm?
These are the benefits also will be getting.
You are aware of this 1st of July 2020?
Which I have not come across. I know that some notification is there, but I have not come across.
This petition was filed in 2019. Does it take 3 years for a person who is doing up this matter to take it up? As per this 1st of July 2020, your continuation of service is there till 60 years. For all 29,701 numbers of contractual teachers subject to satisfactory annual performance report and signing of fresh agreements clearly indicating annual appraisal, disciplinary rules, etc., as per the draft at Annexure 1, medical reimbursement benefits up till 5 lakhs annually for teachers and his immediate dependent, casual leave, earned leave, maternity leave, child care leave, as will be entitled as per rule for a vacation department, entitlement of salary as per the revision of pay rules, ROP, and benefit of CPF will continue as per the existing rules. No pensionary benefit will be delivered to these teachers. Entitlement to avail bank loan at par with other state government employees. So only is pension. What else are you going to get benefit? If you are regular?
And Lordship, that if somebody dies, then normally his relative get the entire salaries of service period.
My goodness, you want the
Remaining service.
compassionate family pension also.
No, that is important.
But that memorandum is only for government servants.
Lordship, then therefore we wanted to be absorbed in.
How can you get that unless you are entitled to pension?
Yes.
There is a compassionate family pension. Your only grievance now is pensionary benefits.
Yes, yes, sir.
Now you can't get a pensionary as per these two under the. Why these people have not been included within the ambit thereof?
In fact, the rule envisages, my lord, pension.
Which one?
Yes, please. Education. Please come to page 265, my lord. Is there Assam Right of Child to Free and Compulsory Education Rule 2011 under the RT Act? Please come
Yes.
to Rule 18, my lord.
Allowance and conditions of teachers for the purpose of government.
The government, autonomous council, or the local authority, as the case may be, shall notify terms and conditions of service and salary and allowance of teachers in order to create a professional and permanent cadre for teachers. In particular, without prejudice to sub-rule 1, the terms and conditions of the service shall take into account the following: accountability of teachers to the school management committee constituted under section 21, provisions enabling long-term stake of teachers in the teaching profession. Now 3, the scale of pay, allowance, medical facilities, pension, gratuity, provident fund, and other prescribed benefit of teachers, including those employed for the purpose of imparting special training as specified in section 4, shall be that of a regular teacher and at par for similar work and activity. But while, my lord, pursuant, now lordship has already seen that notification of 2000, my lord. Pursuant to this, an agreement is required to be signed by the employer. Pursuant to this notification of 2000.
That I don't know. I have not seen.
Lordship doesn't 2020, my lord.
2020.
Yes, yes. In terms of this, we are entitled to the 7 benefits, my lord. Now here pension is not mentioned, though in the rules we are entitled. And more importantly, my lord, in terms of the after this, we are supposed to enter into an agreement. And in that agreement, there is a extra. My Let me have a kindly look at this clause 3. Okay. Now it is a fact, my lord. Now retrospective effect. That clause 3, my lord. During the period of the instant contract, the first party will entitled to continue to draw salary and increment as per ROP in force, and also the benefit of CPF, etc., as is being drawn as per existing system. In the existing salary and scale of pay, the first party will not be entitled to any kind of pension and or any other pensionary benefit on their completion of service on attaining the 60 years of age, or prior to that in the event of termination, death, resignation, or any other event which may lead to cessation of service. Now, my lord, in case of a normal government servant, my lord, the cessation of service can happen only by virtue of death or by virtue of some disciplinary action. Otherwise, he has a right to continue up to the age of superannuation. This is not very clear, my lord. The fact that I will continue up to 60 years, subject to some disciplinary proceeding, that is not. That clarity has to be there. That means, in terms of our original appointment, my lord, when we are appointed on contract basis, as Lordship is correct, my lord, now perhaps the dispute boils down to pension, number one, and secondly, whether we are entitled to this benefit from 2020 or we are entitled to benefit from the date of our appointment.
Means for your qualifying period?
No, my lord, from the date of our appointment, because as per the scheme of the government of India, we could not have been appointed like this. We have annexed all those documents in our petition. All right. Item number, I think, 24. So, my lord, that clarity has to be there. Is it subject to disciplinary proceeding, or because at the whims of the, my lord, authority also, if they feel that we are guilty of something, whether our services can be done? That is not very clear.
No,
They have
here
given
it
otherwise
has been
many
mentioned that your appointment,
Yes.
contractual or satisfactory annual performance report and
Yes.
signing of rare clearly indicating annual appraisal.
No, my lord, in case of a normal government servant, there is no such condition. Supposing my performance is not good, then I may not get a promotion. But there is no question of, my lord, throwing me out. But here that aspect is there. Slightly delicate, my lord. It's of course, by and large, my lord, now they have given everything other than pension. That too from 2020. What will
And
happen?
all these petitioners are in service.
Yes, all right.
So obviously now they are
Yes.
they are getting the
And this has
benefit of
happened
that.
during the pendency of the case.
So now they are getting the benefit of this.
Yes, with effect from 2021, we are getting regular scheme.
But how can a pension be granted unless there is some notification to the effect by the government?
Therefore, my lord, since they have already incorporated in the rules that will be entitled to pension, now they have to make necessary provisions in the rules or whatever OM by any other OM, my lord. As long as, my lord, government is prepared to give, they can always come up with either a rule, statutory rule, or an order under Article 162.
Because you can right to compulsory.
My lord will kindly have a section 4, my lord. Section 4, and section 23 or 3, my lord. qualification for appointment and terms and conditions of service of teacher. Any person possessing the minimum qualification as laid down by an academic authority authorized by the central government by notification shall be eligible for appointment as a teacher. Whereas statute does not have adequate institution offering courses or training.
So we are concerned with 23.3.
3, my salary and allowance payable to and terms and conditions of service of teachers shall be such as may be prescribed. Now the state has prescribed where it includes pension.
Now all these repetitions have been filed in 2019.
Mostly, na? 18 and 19, I suppose.
No, not 20.
No, after that.
So this aspect was not there.
At that point of time, it was not. This is a development having
So
taken
we
place.
further develop it
Yes.
by this order
If necessary,
and
my
ask
lord,
them.
we can bring on record this notifications and
No,
an
he has
agreement.
given it. I'll put it on record as Annexure X.
Yes.
And
And I
then
think, my
take it
lord, we need to
develop.
challenge this agreement also.
Huh?
We need to challenge this agreement, my lord.
Why?
Because it says that I will not be entitled to pension. It's contrary to the rules. State government will prescribe, state government has prescribed that we will be entitled to pension. Even then, my lord, they have included a clause.
Item number 39 and 40 is of 2020.
2020 means when? 39, 40.
This is of 1st of July to the 2020.
Perhaps before that.
I think, my lord, COVID started in March. So until the end of 2020, hardly there was any litigation filed.
Whose is matter is 39 and 40? Did you file to stop? Did you filing to stop? This was filed on 20. One is 24/2, and the other is, let's see. These are all prior to 1/7/2000.
1/7/2020.
So now, although your prayer was for regularization, now it has been modified.
Yes, my lord. To that
Because
extent, my lord,
that is a difficult thing which can't be granted. But now, in view of this
the only
notification,
thing is, my lord, some protection has to be given to the petitioners regarding their continuity of service up to the age of 60. That some, means has to be devised. Because otherwise, my lord, that's a gray area.
where is that? You gave me that, no? Where is that?
Yes, just now I gave.
During the
There, of
period of
course,
the
that-
instant one, the first part, now first paragraph, clause 1 says the first party shall remain in the service of the school as assistant teacher on contractual basis in primary upper school, working as contractual teachers under Ahom Sarva Shiksha Abhijan, engaged to strengthen and improve the quality of elementary education in the state in compliance with the Right to Education Act 2009, with a view to maintain pupil research, especially in the school of remote and isolated from the date of joining, that is so and so, pursuant to this present agreement, till further order or maximum till maintaining the age of 60, subject to the provisions hereinafter contained. So here, but this notification category says the continuation of service till attaining the age of 60
Yes.
in respect of so and so is given subject to satisfactory annual performance
That is
report
where my
and signing of fresh agreement clearly indicating annual appraisal, disciplinary rules, etc. And as per draft annexure, what is this draft annexure 1?
Draft annexure, perhaps the agreement part, but annexure is not received.
Huh?
I think that is the agreement is that annexure
perhaps.
1, madam. The one which Lordship is reading, my lord, that is the annexure.
I don't think so. It doesn't look like that.
I think on
Signing of fresh agreement clearly indicating annual appraisal, disciplinary rules, etc. as per draft.
at Annexure 1.
As per draft, this is the draft. As Annexure 1 with effect from so and so. The annual appraisal will be done during the month of every July. So your thing is that there has to be something or some guarantee which is normally being given.
Yes. Because, my lord, no government servant is subjected to appraisal every year. Unless, my lord, supposing somebody is appointed on probation, then we can appreciate, my lord. Then his performance will be judged, suitability will be judged, then he will be made confirm. But there's nothing like annual. Then, my lord, we retain the character of contractual employee. Then
So
we
that
are-
is why it is a contractual.
No, my lord, we can't be. That is our case, my lord. Now, after having come
No,
up with
is
this
it your
notification-
case that as per the rules,
Yes.
there cannot be a contractual appointment?
No, my lord.
Where is it?
That is our case. If a lordship would, item number. If a lordship would, 26 to diyo. $66. My lord will kindly have this item 24. My lord.
Yes,
Please
just
come
1
to page
minute.
66. When central government, my lord, sanctioned this post, it was clearly indicated that no contractual business, no dual teachers.
Now, in the advertisement, it has been mentioned as contractual appointment. But you have then also participated.
Yes.
Then-
No, my lord, kindly come to page 55 of the litigation matter.
5. Yes.
Minutes of the 196 PAB meeting, that is Project Approval Board meeting.
Page 65.
55.
Oh, 50.
55.
Yes.
Government of India, Minister of Human Resource. Minutes of the 196 Project Approval Board meeting held on 18 March 2013 for approval of annual work plan and budget for Assam. The 196 meeting of the Project Approval Board for considering annual work plan and budget 2013-14 for SSA and KGBV for the state of Assam was held on 18 March under the chairmanship of so. Then my lord will skip over to page 66.
Yes.
9.3.1. Teacher's salary. The state has different appointing authority and procedure of selection of teachers for teachers' position born on the state budget and that of SSC. State budget teachers are appointed by Directorate of Elementary Education and SSA teachers are appointed by State Project Director. PAB advised the state to address the issue as this will create problem in the redeployment in the schools and advised that all teachers should be recruited by the state government even if SSA is paying for teachers post created under the program. So, my lord, then my lord will kindly come to page number 82.
Now, this is only an advice.
No, my lord, this is binding on the state authority.
No. This is an advice.
Yes.
PAB advised the state.
Yes. That's of course.
Yeah. Not binding.
Yes.
Then
Please come to page 82. 9.3.1 was the bottom.
Yes.
PAB expressed concern over large number of vacancies and advised the state to fill up the vacancies born on the state budget first. Funds for new recruits under SSA would be approved only when all state vacancies are filled up. PAB also advised the state to do away with the dual cadre of teachers as all teachers belong to the state. State was also asked to comply with the commitment given in respect of rationalization of teachers by July 2014. PAB also expressed concern on the declining attendance rate of teachers
and student and primary level and advise the state to correct the action. So in my humble understanding, my lord, it is the central government who is providing the money under the SSA. They say you don't have this dual system. You have as a state school of teachers, and you may employ them anywhere. Because when it comes to redeployment, there will be problem. And state government has accepted this, my lord. How can state government now say they are not? They will
No,
not
no,
follow
no.
this.
Where it has been mentioned and whether that who is this PAB?
My lord, Project Approval Board of the Government of India, Minister of Human
Project
Resources.
Approval Board.
Yes. So the
Now,
money is being provided.
is the advice of the Project Approval Board binding on the state?
Yes.
How do you say so?
My lord, it is, my lord, it is something to do with, if your lordship kindly recollects, NP 66 of list 1. I'm going to give you an example, madam. It says that standard of education will be laid down by central government. Then, my lord, education is in the, my lord, concurrent list, entry 25 of list 3. There, my lord, when the state wants to do anything, state section will be subject to entry 66 of list 1. So therefore, my lord, state cannot do something which is in conflict with the central's prescription in any matter, my lord. That is why Article 254 is there. That's why it said, my lord, if you want to have a law which is inconsistent with the central law, then the law must be reserved for assent of the president before it is introduced in the assembly. That is how the balance is maintained.
But with the advice of a body,
yes,
on the basis of Article 254 or the article entries in the Constitution would have any relevance?
Though the word advice is used, my lord, in effect, it is the direction of the central government, my lord. How can they say they will not? Because the money is provided by whom? Money is coming from center. It is the center scheme.
But the central government has not done anything in spite of these people who are having the contractual appointments.
That's why central government said you should not have this. The recruitment by this should be by the state. There could not be any recruitment, separate recruitment for SSA and separate recruitment for the state government. There will be only one recruitment. That's what the central government says, my lord. The money is being provided by central government. I think these
Shouldn't
are
the union be a party then in these proceedings? If you are raising that issue,
yes.
Has the union been made a party?
Union of India, I think we have made party, my lord.
Union of India is there.
We have made them a party, my lord.
They have not filed affidavit?
They have filed.
Yes, what is your stand, Mr. Datta? You have filed affidavit where?
Item number
30? 36.
At least copy has not been given to us. So maybe they have filed.
of WPC 8226 of 2019, my lord. Para 2, my lord.
Respond number 1 to 3.
1 to 3, my lord.
Showing the salaries and payable, Rule 18 of the model going so prescribed to the state government or the case may be shall notify terms and conditions of
And Rule 18 also speaks of permanent cadre.
And
state rules. Eight. My lord, my learned friend is saying there is a repetition 8112 of 22, wherein my lord, the non-giving of pension is under challenge. along with their agreement.
Where is that?
It is not before your lordship.
Not that, but that has been filed. That the rule has been
Rule has been issued. Then we will hear it after 10 years. Wait. But Mr. Chaudhary, the central government says that we have nothing to do.
In the affidavit.
It is all the
We have
state who has to
advised-
do it.
How can they
we have
say that, my
advised
lord,
the-
they are laying down the standard?
Yeah,
They're
it
laying
says,
down
you
the
see,
norms.
on this dual cadre, what they say. They, as regards the statements made in para 9 and 10 of the requisition, the deponent begs to state that the project approval board of the Ministry of Human Resources in its 2013 meeting advised the state to do away with the dual cadre of teachers, as all the teachers belong to the state. However, the decision in that regard is to be taken by the state government. Then you see here, paragraph number 4. Further, it is begged to state that in order to provide better education to pupils of different schools under the elementary education by engaging qualified teachers in other words, with the aim to uplift the standard of teaching in elementary school levels to achieve quality education, the state government, in compliance with the RTE Act, by publishing the advertisement concerned, appointed the petitioners with such terms and conditions stipulated in the said advertisement. And therefore, the authorities of the Union of India has no role in that matter of appointment of the teacher. In that regard, the deponent begs to reiterate his statement made in paragraph number 2 of this affidavit.
Then why are they laying down the norms, my lord? Anyway, my lord, there is a legal answer to it, my lord.
I think a legal answer we have to develop.
Yes, we'll develop.
Rule, that particular rule
No, my lord,
1823.
we'll have to, my lord, by drawing support from the 3 lists, I think argument will have to be developed.
Where?
Drawing support from the 3 lists, my lord, especially list 1 and list 3.
No, you see, if you see section 23(3),
Yes.
it says it may be prescribed.
Yes.
It doesn't say the state, central government or the state government will prescribe.
For example, my lord, in the state rule, Rule 18 is speaks of pension. How come they are saying that in agreement no pension?
No, that is why what is required is
Regarding the mode of recruitment.
Rule 18 aspect has to be, I think, brought within the fold of these petitions.
No, my lord, matter can be looked at from this angle. Normally, supposing, my lord, in social welfare department, the ICDS projects are there. Now, how an ICDS project to operate, it is the central government guideline which lays down. Now, if central government lays down a particular norm for recruitment and all, how can states say will not follow? Similarly, here, my lord, now it is the central government who is providing the fund. The central government says that first you exhaust the money in both the cadres by making a single recruitment. Thereafter, our money can be utilized. Because they may come, my lord, supposing a time will come when supposing, my lord, the basic objective is met. That means universalization of elementary education is done. Then those teachers cannot be thrown away. And at that point of time, what will? Well,
Now, as of now, the central government has not come up with any rules to that effect.
No, I appreciate, my lord. The affidavit, they have taken a very evasive stand. But we'll have to find out some legal answers to that. And I think we'll find out, my lord. There are answers to it. Why state is bound to follow that?
No, if we see Rule 18, which is a rule made under the provisions of this Act.
Yes.
By the state government.
Yes.
Wherein it emphasizes pension.
Yes.
Why the state should not give the pension?
Exactly. Exactly.
Why should we go more into anything else?
Yes, yes. My lord, they have prescribed. Now they profess that they will carry out this mandate. My lord, when money is coming from central government. There's no difficulty as far as SSA is concerned. They say this is how you have to make recruitment. All right. Now you have made.
Now tell me, Mr. Datta, there are many people who have retired also.
Yes.
In respect to this Sarva Shiksha. Has anybody retired or not? What has the central government done as regards you are making payment of the salary?
That situation may not have reached,
State
my lord.
government have not pay any salary from our end, from my central government.
Salary who is paying?
State government, man.
Not from the central fund.
Not man.
Central is not giving any money.
Not giving.
Mr. Chaudhary, the central is not giving any money.
My lord,
He's saying the central is not giving any money.
it's settlement.
Other regular.
What for? My lord, the
other
heading of the
regular
PAB,
teachers,
my
my
lord,
lord,
proceeding.
receive from the state government, man.
Huh?
Receive from the state government. Other regular teachers.
Chalo, we call the director of Sarva Shiksha to understand the concept. We call the director of Sarva Shiksha to be present, as the council is not there. Chalo. Heard Mr. K. Chaudhary. First of all, Mr. Chaudhary,
My lord.
you may ask your juniors to pay the deficit court fee.
Yes, yes.
It is not.
We'll do, my lord.
Heard Mr. K. Chaudhary, the learned senior counsel, Mr. B.D. Goswami, Mr. D.P. Bora, Mr. N. Anybody else? Mr. R. Goswami, Mr. T. Deuri. Anybody else? Okay, give your names enough. So, Mr. A.K. Dutta appears on behalf of the central government. Mr. P.N. Sharma appears on behalf of the elementary education department. Mr. R. Bopuzari appears for the finance department, who is a party in WPC number? Number 20 and 25, WPC 4246 of 19. And? WPC 5973 of 19. Of 19.
I think, my lord, the other petition where they are challenging that pension aspect, 8111 of 2022, that may also be tagged, my lord.
Please look into it. During the course of hearing, it transpired. During the course of hearing, the Learned Counsel for the Elementary Education Department has produced a notification dated 1/7/2020, issued by the Commissioner and Secretary to the Government of Assam Elementary Education Department. It is relevant to take note of that the same notification has been issued pursuant to filing of the instant writ petitions, instant batch of the writ petitions. Taking into account its relevance, the entire notification is extracted herein under. Ekita nalage de 1, 2, 3, 4 ekita nalage koro. Iya lage ribo memo lage. Uporo pra memo. ठीक है एक करो ekita nalage. From a perusal of the said notification, it transpired that the government of Assam, that the cabinet of the government of Assam had taken a decision to grant certain benefits to 29,701 assistant teachers, bracket SS oblique MS, bracket close, in lower primary oblique upper primary schools who have been working as contractual teachers under the Ahom Sarva Shiksha Abhijan mission. And have been engaged during the period from 2012 to 17, and who joined their services on or after 1/1/2018. Various benefits have been given. However, clause 5 stipulates that there shall be no pensionary benefits delivered to these teachers. During the course of the hearing, Mr. K. Chaudhary, the learned senior counsel, has also produced a copy of a draft copy of an agreement form wherein it clause 3, it has also been mentioned that the teacher in question would not be entitled to any kind of pension and or any other pensionary benefits on their completion of service on attaining 60 years of age or prior to that in the event of termination and or death, resignation, and or any other event which may lead to the cessation of service. The Learned Senior Counsel has also drawn the attention to section 23(3) of the Right of the Children to Free and Compulsory Education Act 2009, which mandates that the salary and allowance payable to the teachers and the terms and conditions of the service of the teacher shall be such as may be prescribed. He submits that in pursuance to that, and in exercise of the powers under section 38 of the Act of 2009, the state of Assam, where is that page you are mentioning? Got it.
265 is the relevant.
The state of Assam had framed the Assam Right of Children to Free and Compulsory Education Rules 2011. The Learned Senior Counsel has drawn the attention to paragraph, it's rule 18. Of the said rules of 2011, which stipulates the salary and allowances and conditions of service of teachers for the purpose of section 23(3) of the Act of 2009. The Learned Senior Counsel, drawing emphasis on Rule 18(3), submits 18(3) of the rules of 2011, submitted that the scale of pay and allowance, medical facilities, pension, gratuity, provident fund and other prescribed benefits of teachers, including those employed for the purpose of imparting special training as specified in section 4 of the Act of 2009, shall be that of a regular teacher and at par for similar work and experience. The Learned Senior Counsel therefore submits that in that view of the matter, the petitioners herein, apart from the benefits which have been granted, in terms with the cabinet decision dated 1/7/2020, would further be entitled to pension, gratuity, provident fund, etc. The Learned Senior Counsel, however, submitted with all fairness that this development as regards the additional benefits so given has only come into effect have only come into effect from 1/7/2020. And as such, the petitioner may be permitted to bring the said aspect of the matter by way of an additional affidavit. Otherwise, it doesn't become
Right. Part of-
tomorrow. If I direct also this, you may say this is not a part of the pleading. It is, however, the petitioners are given the liberty to file such additional affidavits. In terms with the submissions in additional affidavit as deemed fit. And also bring on record the notification dated 1/7/2020 and the agreement, draft agreement. The counsels appearing on behalf of the petitioner submits that the same would be done within a period of 3 weeks from today. It is, however, it is also relevant to take note of. Before parting, this court finally also finds it relevant to take note of that although the grievances of the petitioners in the various batch of petitions may be the same, but the cause of action for each of the petitioners are separate and distinct, claiming their benefits, individual benefits. However, it is seen that in the batch of petitions, the court, although there are various petitioners, but the court fee of only one petitioner in each petition has been paid. The learned counsel appearing on behalf of the petitioner submit that they would pay the deficit court fee by the next date, on or before the next date. Taking into account the same, list the matter again on 6th of June, 6th of June for further consideration.
We may be allowed to.
This court further would also take note of that the Assam Sarva Shiksha Abhigyan is the main party to the instant proceedings. However, when the matter has been called for, there is none to represent the said authority. Taking into account the same, this court therefore directs either the director of Assam Sarva Shiksha Abhigyan, regional director of the Assam Sarva Shiksha Mission, they are director of the Assam Sarva Shiksha Abhigyan to be personally present on the next date, or the said authority be represented by the council without fail.
Well, I think a prayer regarding another case, whether Lordship will kindly consider that 8 of 2020. Same, eventually it will boil down to the same relief matter.
There, another analogous matter, it has also been drawn the attention of this court that there is another analogous matter. That is WPC number
8111 or 8112
8112/2020.
22.
The registry is directed to list the said writ petition along with the present.
We may be allowed to add finance department.
Not necessary to the in two petitions they are there, na? Don't worry.
In my cases, two IAs are there for correction of names.
Correction of name.
28 and 29.
I'm coming in 5 minutes. Wait.
Well, it is voluminous only because of the names, my lord. Altogether, 1,200 and odd petitioners were there in the restriction. My lord, out of that, my lord, mistakes have occurred in 430 cases, my lord. Either name or address or title. That list is given, my lord, at page 60, my lord, from
What is this? Kindly come to page 322 of that volume.
320.
Oh, these IA.
Yes, ma'am. I am.
Now, what is this IA for?
IA is for correction of the, my lord, either the name or the name of the school or the address, my lord, typographical error.
Where?
My lord, that list I have given, my lord, at page 596 it starts.
Page
596. My lord, that is the in 7723. Wait.
withdraw the petition, file a fresh one. It is impossible. How can this be done?
My lord, we can give soft copy, man.
Not soft
In,
copy.
in the pages, my lord, where
No. Where is the question of soft copy and all this business? 1041, you want every for all these 430 petitioners, you want a change. How is it possible? Tell me. To make those corrections, if so the petition, file a fresh one. If you want these corrections, you should have been careful when you made this petition.
when actual number of petitioners were very large, my lord.
So, and court fee?
And court fee will definitely give that.
No, understood. You have not paid that.
That was not.
So, you don't lose much except the pages. You file a fresh one.
Press rate.
You file a fresh one that because I understood that if one mistake, two mistake, three mistake, but these are 431 mistakes. This court has to say in every aspect this message, this needs to be corrected.
Like Manik Bora, Manik Chandra Bora,
Huh?
Samoguri.
Then, like 416. Labanya Datta, it is LABO.
Yes.
So you want this correction, otherwise daughter of so and so, whether you want to correct or not, that is your lookout. One here 414. You have made PS Sodor, but it should be PS Jazuri. Do you expect all these things to be corrected?
We'll file press petition, man.
Or Mr. B.D. Goswami, the learned counsel appearing on behalf of the petitioner.
My lord, your lordship will not insist on press Okalat Nama.
Huh?
Just a writ petition will type. A corrected writ petition will type and submit it, my lord.
Unless there is an amendment, how is it possible? You have to file a fresh one.
My lord.
How is it possible?
Yes, my lord. In that case, my lord, Okalat Nama will not be necessary. Your lordship will allow us to amend it by filing a fresh writ.
It means I am allowing this amendment.
Yes, yes.
If I am allowing this amendment, is it your application for filing an amendment?
No, my lord, no.
You are for correction.
For correction.
Then how is it possible?
Oh, yes, well, that is not it.
You are seeking an amendment, then amendment I can allow it. Okay, we'll do one thing.
My lord.
Just convert it to an amendment application.
That your lordship.
What do you say? And then let them file a fresh amended application. Huh? Because here it's a case of not correction, it's a case of amendment.
But only thing, my lord, Okalat Nama, it will be difficult.
Not necessary, na?
Yeah, no.
But you have to pay the court fee.
Oh, yes, definitely. Well, that too we have to pay, my lord.
But Mr. B.D. Goswami, the learned, there's only one petition or
My lord.
only this one?
No, my lord, two IAs are in two cases. There were two cases, 28 and 29. 29 is, my lord, very little, my lord, not like this.
Mr. B.D. Goswami, the learned counsel appearing on behalf on IA 760/2020. Mr. B.D. Goswami, the learned counsel appearing on behalf of the petitioner. Who is appearing for whom?
I am for the alimentation part.
Mr. P.N. Sharma appears on behalf of the Mr. A.K. Dutta appears on behalf of the respondent numbers 1, 2, and 3. Mr. P.N. Sharma appears on behalf of the respondent number 4, 5, 6.
Okay.
None appears on behalf of the respondent number 7, 8, and 9, although their names have been shown in the cause list. The present application has been filed seeking amendment to the cause title of the writ petition in view of various typographical errors which have been mentioned in paragraph number 3 of the application. Taking into account that those are typographical errors and would not change the nature and character of the writ petition, this court permits the amendment, thereby allowing the instant application. The petitioner is granted 7 days time to file the amended writ petition on the basis of the order so passed. 15 days, 14 days. Today is granted till today is 4th. To file the granted time till 18th of May 2023 to file their amended writ petition. Extra copies of the amended application be served upon the respondents at the time of filing of the amended application, amended writ petition. Accordingly, the instant IA stands disposed.
And item 29.
Correct.
IA 731.
7?
30.
652 and 346. Available. Mr. B. Chaudhary, I have asked the director of Sarva Shiksha to be personally present on next week.
Lordship, I apologize, Lordship. It was supposed to be done by Mr. P. Gogoi, but he is on legs in court number
Can't
4
help it.
since morning. That's
So
why,
let him be
Lordship,
personally present.
Lordship may, he will, Mr. Gogoi will apprise, Lordship may take it up on Monday, Lordship.
Sorry. Yes. One was the paragraph.
Well, para 3, my lord, page
Paragraph
35.
3. Paragraph 3. Okay. Huh? File it within such time.
Must.
Yet, Kali Union of India, I don't think whether Union of India is a party. I say, same. None appears on behalf of the respondent number 7, 8, and 9 in spite of it. According to order,